Hello and welcome to Defense Diaries. I'm your host, Bob Mata, and this is our continuing coverage of the people of the state of Idaho versus Brian Kohberger. So it's been a minute since we visited Mr. Kohberger out in Idaho. There's been a lot going on recently. As a matter of fact, today, I think it came down today, we got a ruling on the motion of Ann Taylor and Brian Kohberger in order to try to get the death penalty taken off the table. I'm going to start with that. There's a 55-page memorandum, which we're not going to go through tonight because, frankly, the volume of motions that were filed, suppression or otherwise, are very lengthy. So we will not have time. We'll go through the death penalty thing at a later date. It's interesting though, because it's obviously a big deal when they're deciding whether or not the death penalty is going to be applicable in this case. And clearly it has to be a well thought out ruling and opinion by the judge, which it was. So we will definitely get to that. But let's just kind of pull up, and Allie's going to be joining me momentarily. Fear not, fear not. I want to pull this guy up. First, let's take a peek at it. So it's a little fuzzy. I'm not sure why. Let me go into, hold on. Let me go into DND. I'm on DND. Still always getting bingings. Never understand that. All right, so this is the memorandum decision in order on the death penalty motions that were filed. Introduction. The defendant is charged with 1 count of burglary and 4 counts of murder in the first degree in connection with the deaths of 4 University of Idaho students. The state has filed a notice of intent to seek the death penalty pursuant to Idaho Code 18-4004A notice before the court are 12 motions filed by the defendant challenging various aspects of Idaho's capital punishment scheme, collectively known as the death penalty motions. A hearing on same. Hold on, let me get it into right read mode. Scrolling. A hearing on. I don't know where the rest of it is. It's not me, right? It's a hearing on the, and then we go to id. So I don't know. Yeah, it's weird. So defendant acknowledges he has not identified an alternative method, but contends his claim is distinct from the method of execution claims in Bucklew, Bays, and Glossip. He argues Idaho's chosen methods are unconstitutional because they threaten Idaho's citizens with a means of execution that, quote, cannot be carried out without causing undue pain, end quote. However, this is not it. Hi.
Sorry.
This is not a
those circles.
Oh, yeah, I don't know why it's all here. Use this one, I bet.
It's all right. I didn't mean to interrupt. I thought I could.
Boop. There you go.
You did it.
I did it. However, this. What?
Never mind. I was gonna say it might have made the font smaller for the people.
Oh, well, anyway, let me in introducing my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, y'all.
Hey, I was kind of jumping in. I was just going through the real quick order that came down on their death penalty motions that they had filed a while back, and there was a ruling on that. I think this came down yesterday, the 19th. So again, he argues that Idaho's chosen methods are unconstitutional because they threaten Idaho's citizens with a means of execution that, quote, cannot be carried out with causing undue pain. However, this is not a distinction that can be drawn. Undue pain is precisely the question that the foregoing method of execution cases address. To strike a method of execution is unduly painful under the Eighth Amendment. Defendant must come forward with an alternative method. He has not done so, thus foreclosing his claim. In the order of the court, based on the foregoing analysis, defendant's death penalty motions are hereby denied. So it sounds like they weren't arguing it on grounds, and that's the new judge, Hippler. They were not arguing it on grounds that it should not apply for other reasons other than the fact that it's, in their estimation, potentially cruel and unusual punishment. All right, so let's start digging into, because there's a lot, and we'll see how long this goes. Like Allison, you guys know Allie, probably about midway through, because a lot of these memos are
I mean,
17, 18, 20 pages.
all I was suggesting is that you definitely skip things that just say, I'm going to bring a motion, and then there's a separate, just go right to the memorandum.
Yeah, I mean, they're so short, though. It
Go
seems
ahead.
like we're putting the cart before the horse if we do that a little bit. I don't know. All right, so this first thing is a motion for a Franks hearing. If you guys follow us, you obviously know what a Franks hearing is. But in case you don't or you're new, Allie, just give a real brief description of what a Franks hearing is.
A Franks hearing is when you challenge the either a search warrant or an arrest warrant on the face of the affidavit in support of warrant to indicate that it was insufficient or had incorrect information, erroneous information, misleading information, and that it should have never been granted. Typically, it's like they bullshitted you, Your Honor, and now I'm going to show you why.
Right. And she's making the argument in some of these that there were omissions, and we've talked about omissions that were, especially in the Allen case, there were many things that the defense was arguing there that should have been contained, that had they been contained within the application for the search warrants, that it may have given the judge pause as to probable cause as to Richard Allen being the guy.
Well,
Ultimately.
Idaho law, thankfully, specifically says and sets the parameters for when an omission amounts to something material that would warrant, suppression of evidence.
Yeah, and there's kind of a
Fraudulent warrant.
rule of thumb that I want to explain to everybody, just not just for this case, but for any case that you're ever watching or any case law you're ever hearing some lawyer read about. The way that it works in our country is that the Constitution is our baseline, the federal Constitution. All right, now, as you guys all know, or you should know, each state has their own constitution. Now, once the federal constitution lays like a baseline of what our rights are, states can give us more rights, but they cannot give us less rights than the federal constitution affords us. So
And if their state constitution gives more rights, the judges have to, enforce the Constitution. So at times you will see it going to the Supreme Court, and they'll argue either under federal law or our state specific statute, which affords the citizens more protection than does the U.S. Constitution. It violated the Constitution, and sometimes the U.S. Supreme Court will say, all right, yeah, it violated the state constitution.
okay. All right, so we're in this thing where they're asking for a Franks, and just so you know, going in, a ton of these motions are, and it was kind of driving Allison a little bit nuts because there's going to be gaping holes for us from a legal analysis point of view because of the fact that everything that's relating to the IGG stuff, which is very much in dispute right now and it's being litigated, but it's being litigated under seal per judge, the former judge's order. All right. So everything that is coming and Ann Taylor's kind of basis for this thing is that sheath that they used, which seemed to be their primary, at least everywhere aside from Pennsylvania, which seemed to be one of their primary thrusts, one of their main pieces of evidence, we are saying is something that should be completely excluded because of what they did with that IGG. So it's going to be a little bit frustrating when we're trying to analyze this because like that's a big gaping hole where I think that she filed these probably feeling some heat in terms of, the trial date's coming. Like we're already in November and this thing is set to go, I think correct me if I'm wrong out there. I think it was in July. They set a trial date for this. And I've said it, if I've said it once, I've said it a million times, 6 or 7 months in a case like this is the blink of an eye. And as you can see, these have to be litigated. So I think she was feeling like I got to get these things filed because the state is obviously going to have time to respond to these, each and every one of them. And at that point, then the judge will set a hearing date for argument and, witnesses if necessary. So that's kind of why we're seeing these now. When I think in a perfect world, she would have waited for a ruling on the IGG stuff before she filed these. But I think if they're taken in the order that they were filed, we should get some answers on the IGG stuff before too long, I would hope. But again, Hippler, the new judge, he has to familiarize himself with everything in this case. It's a big disadvantage for a judge to come in kind of midstream in a case because it does matter. It's not like they just can go sit on the bench and say, oh, okay, well, what's going on? It doesn't work like that. They have to familiarize themselves with all the issues that are in front of them through other pleadings that have been filed predating that judge sitting on the case. So it's a lot of catch up for Judge Hippler. And plus, I'm sure he has his own call, that he's got to deal with on a daily basis. So it's a lot of work for that particular judge.
And then just to kind of touch on the other part of it that makes it, frustrating or harder to analyze is that there's no details about what specifically they're looking to suppress, where it was located, and hence why the legal analysis applies to that specific evidence.
Yeah. Okay. All right. So we've got, this motion is made pursuant to the Fourth Amendment of the United States Constitution and Article 117, Section 17 of the Idaho Constitution and Franks v. Delaware, 438 U.S. 164. A proffer and exhibits are filed contemporaneously in support in accordance with State v. Fisher. The parties stipulate to the sealing of the proffer and exhibits. A stipulation is filed contemporaneously. The under seal proffer and exhibits are being provided to opposing counsel and court staff via email on the date of this motion. All right. So unlike in Allen, we're not going to get to see that. And then this will be the kind of the last one I read, Allie, before we get into the memorandums, because this is kind of like what I was talking about with this IGG stuff is really why we have some of these gaping holes in terms of why I think we're not seeing some of the things you're asking for, specificity. I mean, there's some specificity, in terms of Google searches, but not really. Like we're not hearing like what Google search. It's like immediately, like as soon as you started reading it, Allison's like, oh, well, I guess he did have Google searches or Amazon purchases or whatever the case may be. I don't know if you guys remember when Dateline aired that thing in Coffindaffer, they had her come on basically unequivocally stating that she got information from some inside source that they found the purchase of the knife in the sheath, which I was like, whoa. I'm like, what is, like I had fired off a pretty heavy-handed tweet aimed at Dateline that I thought that was incredibly irresponsible for them to air that. And we talked about that story the other night. That's when Shane Bishop came up to my table at CrimeCon and was yelling at me. that he was upset that I was critical of their episode. I said, well, too bad. So, all right. So we've got a motion to suppress regarding the genetic information. This was the second motion filed. Now, there's a difference, y'all, between motions and memorandum. Typically, the motion, depending on what kind of, how the state operates, if it's a state that says, okay, it's a notice pleading, meaning you're just giving notice that you're filing a motion. You don't have to get into all the facts in that pleading. And then we expect you to file a memorandum of law, which will break down exactly what your arguments are and what the issues are. So it appears to me that Idaho is in fact a notice pleading state. And that's why we're seeing that these memorandums are coming in. That's where you're getting the lengthy arguments. So, but some states will have it where your motion contains the law and the issues. Just depends on the jurisdiction. So comes now Brian Kohberger through his attorneys of record and moves to suppress all evidence illegally gathered by law enforcement using his genetic information. So this is kind of what I would consider to be a catch-all motion. This is going back to that thing that I was saying, but for this genetic information that they had, which, as we know, they were able to do a dig in the garbage. They pull out something that has his dad's DNA on it. They get a profile of his father. They then go through some IgG and they come to the conclusion that this guy is who we think is the defendant in this case's father. So that's very much in dispute right now. So that's, and again, that was a very heavy basis in the probable cause affidavit for the arrest warrant. So you can see why Taylor would be arguing that, because if that goes away, then we're talking about some pretty heavy duty fruit of the poisonous tree, unless there's a workaround for the judge where the judge can say, well, I'm going to toss that, but I think there was sufficient probable cause based on everything else. Or, all right. So this motion is made pursuant to the Fourth Amendment of the United States Constitution, Article 1, Section 17 of the Idaho Constitution. A memorandum and exhibits are filed contemporaneously in support under seal. This motion is being filed under seal pursuant to the Honorable John Judge's previous order stating that pleadings related to this motion be filed under seal until the court could review the issues and arguments are filed. The under seal memorandum and exhibits are being provided to opposing counsel and court staff via email on the date of this motion. All right, so we're going to start digging in to the actual memos. So the memo, and they're lengthy, and we're going to do the best that we can to kind of break it down for you. I got an email that I saw that was very good, very lengthy. It was a bunch of, it was quite a few questions, like 10 questions that they were hoping we could answer. It was very lengthy. I apologize. I didn't pull that up, that email up until probably about 10 minutes before the live. So from that perspective, I didn't get to read through it all, but I want it noted that I read it and it's good. And I think that we're going to probably strike on most of the things. I think at the end of the day, what our goal here is, Allie, is to try to figure out whether or not we think any of these motion have legs. And if they do, why? And if they don't, why not? And, it could be part of it that we feel that it's missing important information, that there's not enough specificity in these motions in order for us to really reach a conclusion. So let's get started on the first one. It's a motion to suppress a memorandum in support thereof. And this is regarding the Amazon account, the federal grand jury subpoenas and the warrants dated April 26th and May 8th of 2023. So comes now Brian Kohberger. Brian, through his attorneys of record, and submits the following memorandum in support of his contemporaneously filed motion for an order suppressing all data found by law enforcement from its search of his Amazon account. The motion and documents in support of a Frank's hearing are hereby incorporated into this memorandum. The proffer with supportive documentation regarding Franks are filed under seal. For that reason, we are not set forth in full detail here, but instead are incorporated. So you guys get what that means, right? So like we're missing a ton of information because it's contained in the sealed motions, which may very well contain the specificity that you're looking for, Allie.
Right.
So
You mean but the specificity, but of what specifically they're looking to suppress as a result of it?
maybe, I mean, because that can be very telling, right?
Yeah.
Right. I mean, like specificity, like we all want to know if one of the issues is, did they find a search for the sheath or the purchase of the sheath and the knife? Right. I mean, we all want to know that. So who knows? We're left speculating. So Taylor lays out 3 issues. The first one is that Mr. Kohberger has a privacy interest in his Amazon account information protected by Article 1, Section 17 of the Idaho Constitution and the 4th Amendment, requiring information that requires a warrant. The second issue is that the affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. And then 3, the affidavit submitted in support of the application for the issued search warrant included information that must be excised. So, and then there's subparts A and B. All information in the affidavit was gathered because of law enforcement's unconstitutional use of IGG, and thus nothing in the warrant should remain. And then B, information gathered about Mr. Kohberger via previous invalid warrants must also be excised. All right. I might have to, I've been fighting a little like throat thing. So if I'm occasionally muting myself to cough, excuse me for that, but I'd rather do that than cough in all ears. All right. So facts. Pennsylvania law enforcement, along with officers from Idaho and the FBI, raided Mr. Kohberger's parents' home on December 30th of 2022 and arrested him. At some point, an FBI agent subpoenaed Amazon records belonging to Mr. Kohberger's account. Now we go down to here. I'm going to make it bigger for y'all. Sorry. All right. That's better. Okay. So footnote 1, the grand jury subpoenas issued by the government have been the subject of a motion to compel. There is an order to compel their production, quote, if available to the state, or at a minimum for the state to provide dates of the subpoenas. Order on defendants' 4th and 5th motions to compel June 14th of 2024. The state has done neither. The issues in the memorandum are among the reason a copy of the subpoenas are necessary. It is unclear what the subpoena asked for or its scope. The subpoena return identifies 2 iCloud accounts. So that's a problem. Like that is a problem that I think that the judge will probably take issue with in terms of why haven't they turned over these subpoenas?
That to me, the only reason not to turn them over is because you've got an issue with them.
Right. Well,
First of all, subpoenas don't cover that kind of material. So I don't know why they even started with that. Subpoenas cover like whose cell phone is it? And when did he sign up for the service and what number is associated with the account and who's the account holder and what's the email address and where do they live? Not the actual data. Anytime you're dealing with content and even more than content, but
warrant time.
right. Anytime content, warrant time, hands down. And then anything that shows all your movements and basically paints a picture as if that they could have found out by only following you all day long, warrant time.
Warrant time. So on both December 30th of 2022 and January 27th of 2023, and frankly, I'm a little bit shocked that post-arrest, they're not just like shooting out warrants unless they don't have the PC to get the warrant. See, that's the thing. Like with subpoenas, you don't have to go in with the probable cause affidavit and have a judge sign off on a subpoena. It's a very different procedure, which is why it's more attractive to law enforcement. So, it's a little bit of an issue for the state. And it's strange that they still haven't turned it over going on 5 months. So on December 30th, and the 27th of 2023, Amazon responded with records showing Mr. Kohberger's purchases. Perhaps recognizing that subpoenaing Mr. Kohberger's records was a violation of the Idaho Constitution, on April 26th, 2023, Detective Mowry of the Moscow Police requested a warrant for the same information, telling the court that an unnamed FBI special agent had, quote, located requested information. The warrant was amended due to a date error and ultimately issued May 8th of 2023. Now, y'all see the problem with that, right? If they got the information from a subpoena, which is way too overbroad, as Allison just told you, you like, that is not the kind of stuff you're asking for in subpoenas. Okay, those require warrants. And then if you're then turning around and using the information that you got from that subpoena, specifically like, oh, look, here, Kohberger bought the knife. Oh, look, Kohberger bought the sheath, and we got it from the Amazon subpoena. And now you're trying to use that as the basis for your probable cause to get your warrant. You can see how you've put the cart before the horse, right? You can see the problem with that. You don't need to be a lawyer to figure that out. So, like, right off the bat, this thing has some teeth to me, depending on what went down. Now, maybe it's much ado about nothing.
Right. Maybe they just got it's his account. This is his phone number. This is where I don't know.
It would sure be nice if the state just tendered the shit to get rid of all the
Right.
questions.
That's suspicious, but it, like, exceeding the scope of a subpoena is not as strong as exceeding the scope of a warrant. Like, I don't know that you need the subpoena to say, okay, if if the data was content, if you say what the data is, then you could just say, and you need a warrant for that. A subpoena is not sufficient, but she's not writing what the,
Well,
what
I mean, she stated up here, Amazon responded with records showing Mr. Kohberger's purchases. She is saying it.
right. But I thought they also got something else from AT&T.
Well, that's a different memorandum.
Oh,
Like, that's a whole different thing. Like, she's attacking all kinds of stuff right now. So, yeah, I don't know. It's it'll be like, this will be one of those cases where everything that Allie and I have tried to teach our people that follow us and actually know what we're saying, where you don't blame the lawyers for pointing out the violations of constitutional rights. You blame the cops for shitty police work. God forbid if Kohberger's the guy and a whole bunch of stuff, like namely the knife and the sheath, are excluded. Don't be blaming Ann Taylor. Ann Taylor's just doing her job. She's protecting all of our rights as citizens. Understand that. I need to know that you people understand that, because that's the way this shit works in this country. You blame the cops for bad police work, for violating constitutional rights. That's it.
I don't know that the law is, Bob and I we were talking about this earlier, that this may be one of those things that's, setting the precedent or setting the groundwork to make new law when it comes to what rises to the level in the digital data world of violating your Fourth Amendment. Now, what you bought at the store, assuming it was like that, like they know you shopped somewhere a lot and, somehow were able to track down your purchases at a store, you don't necessarily need a warrant for that, So if they had gotten the Amazon, she makes a lot of good points about all the data richness of
Yeah, like,
Amazon.
the meat of this motion is really interesting, and it's a very interesting argument, and it is, and it's like, we know how much data mining that all of these companies do, whether it's Amazon, whether it's Facebook, like, all of them are getting all of our private shit. Now, I mean, if you're fine with that, if you're fine with the government having access to that by going to private companies and just not even having to get a warrant, but just sending out a subpoena saying, hey, would you mind sending us all this information? If you're cool with that, cool. I'm not personally. I mean, I think a warrant, I think that probable cause should always be a baseline. We can't allow for fishing expeditions to start becoming the norm in our country. And a lot of this is exactly what it is. And then what law enforcement just says is, oh, it's a tool. All it is a tool. It's a clue. It's a clue. They like those. Those are their buzzwords. You'll hear these buzzwords from law enforcement people all the time. It's a clue. It's more than a clue. It's like you're just finding end arounds. You're finding loopholes into getting the information without doing it per the constitutional guidelines. I mean, that's ultimately what's happening. All right. So the affidavit for the warrant was signed by Detective Mowry, Exhibit A. However, most of the information in the warrant was cut and pasted from an affidavit originally bearing the signature of Moscow Police Department Sergeant Blaker. But according to Mowry, now the sworn statement of Corporal Payne. So the basic facts that Mowry used to support the search beyond the arrest warrant facts were very minimal. So one, there was a vague reference that, quote, an FBI special agent located an account for Kohberger. Amazon provided order histories regarding customer email, Brian Christopher 1994 at gmail.com. And that's end quote. So how the agent located this was not explained. Two, investigators know that Amazon holds records for identifying devices the customers use to access their account. All linked accounts, other items customers have searched and clicked onto, placed in the cart, viewed, and saved. Who or how the investigators know this is not explained. I mean, do you want the government being able to go through your Amazon Prime accounts without a warrant? And I'm not talking to you, babe. I'm talking to the 614 people. I don't want the government going through my shit. If you've got a warrant, get a warrant. If you got probable cause, go ahead and get your warrant and then go through my shit. You can't just send a subpoena off to a company and say, hey, we have way too much of our lives are exposed in these online accounts, man. It's crazy to me. It's crazy. It's a crazy thing. And it's like when we get to the IGG stuff, and I can't wait to get to that. I can't wait until we start talking about that, because I have a very kind of like a different opinion, maybe even from Allison on this, because we talked about it briefly, and I'm going to digress, but it's a really fascinating area of the law. And it's one that is brand new. It's a brand new frontier with all the IGG stuff. It's such a powerful tool for law enforcement. So much good can come from it. We can identify John and Jane Does that have been unidentified for 40 and 50 years. We want the positives of it. We do. We want all the positives, but there have to be guidelines. To me, it's always a warrant. Have some probable cause before you're allowed to dig. That's it. Like we just, otherwise we're living in like the old Russian state where they were just, they were just all up in everybody's shit. It's like Orwellian type shit. We don't want to live in that world. Believe me. All right. So investigators know that Amazon holds records for identifying devices the customers use to access their account, all linked accounts, other items customers have searched, clicked on, placed in the cart, viewed, and saved. Who or how the investigators know this is not explained. So 3, little information on how Amazon collects and holds data was explained. So 4, the time frame of March 20th, 2022 through March 30th of 2022 and November 1 of 2022 through December 6th of 2022 were selected. So here's the argument. So she lays out the issues and then she gets into the argument. So this is, remember, she gave you the 3 issues. So this is the first one. Mr. Kohberger has a privacy interest in his Amazon account, information protected by Article 1, Section 17 of the Idaho Constitution that requires a warrant. Okay. Now, and you hear lawyers using this phrase all the time, a privacy interest, an expectation of privacy. It's important. It's a very important, very, very important phrase in terms of our civil rights terms of our rights under the Constitution in this country, privacy rights are something that we should all really fight for to maintain. It's that balance, right? It's the balance of how much power do we give law enforcement to solve crimes? Is it to the extent that we're losing every semblance of our privacy in order for them to solve crimes? I mean, we all want crime solved, but I don't know if I'm willing to give up all of my privacy rights in order for them to do it. As a matter of fact, I know I'm not. Like I'm not for that. So like, and to me, there's an answer. It's not like there's not an answer. The answer is get a fucking warrant, get some probable cause, do some police work, get some probable cause, and then come and get it.
It's not that high of a standard as it
It's
is.
not that high of a standard. It's not too much to ask. All right. So both the Fourth Amendment and Article 1, Section 17 protect people's interest in privacy. A person challenging a search has the burden of showing that he or she had a legitimate expectation of privacy in the item or place searched. And that comes from Rawlings v. Kentucky. That's 448 US 98, and then State v. Cohen, an Idaho case. That involves a two-party inquiry. One, did the person have a subjective expectation of privacy in the object of the challenge search? And two, is society willing to recognize that expectation as reasonable?
And I just want to say this is the section right here, Bob, where every motion set has this word for word language. So we'll probably just jump over
All right,
this.
so you guys pay rapt attention now, because when we get to this section and all the following motions, we're not going to reread it a second, third, fourth, and fifth time. So pay attention. We're going to quiz you like shortly after this motion, this memorandum has been read. All right. So the Fourth Amendment has generally refused to acknowledge that individuals have a privacy interest in records held by a bank relying on third-party doctrine. So that's US v. Miller, citing Hoffa, the Jimmy Hoffa. This, despite the fact that the law required such records to be maintained for the purpose of criminal investigations, citing California bankers. Okay, unsurprisingly, the federal Congress responded negatively. See Right to Financial Privacy Act of 1978. As this court is no doubt aware, can you guys see that? I'll make it a little bigger. As this court is no doubt aware, the third-party doctrine holds that information shared with anyone with whom a person does not have a recognized evidentiary privilege is free for the government to take without a warrant. To put it another way, the third-party doctrine insists, as a matter of law, that you should trust your secrets to no one. And then she cites, this sounds like it's a legal treatise. Yeah, reasonable expectations of privacy and autonomy in Fourth Amendment cases, an empirical look at understanding recognized and permitted by society.
And so just to explain, although it's likely evident, but like the third party doctrine is based on, well, anything that you already share with someone else, that's free game, fair game. So you share your banking records with your bank, you share your phone records with your phone, you share your Amazon records with Amazon. So it used to be very black and white. And as she's going to flesh out here, it's changed. And the Supreme Court has even noted, all right, hey, there is way too much that you can get out of, a cell phone, emails, things like that, that we're not going to say just because it goes through an internet provider and you share it with your whomever that somehow you've lost any expectation of privacy.
Yeah, and no question. And the fact of the matter is that law, it's very fluid what we do. The law is changing, and the hope is always that the law can keep up with society and technological changes. And we have come leaps and bounds in the last 20 years from where we were back in 2000 and even 1990. Like, we're light years ahead of that. Like, all of those things that we're dealing with now have not been contemplated in the law. So new law has to be made. So Marion, your point is exactly what I was talking about. I don't know why somebody pulled it down right when I was about to talk about it.
I
Who was
did.
getting, was that you, babe?
No, maybe you and Tracy clicked on it at the same time. I didn't
Okay.
touch
So,
anything.
but this is exactly what I was talking about with the IGG stuff. It's like, I think that there's an argument that we have and I'm not going to belabor this point, because when we get to the IGG stuff, it's going to make for a fascinating conversation. Really, it is. But I think that we do have I have a privacy interest in, because I share genetic code with relatives that are 2, 3, 4 times removed that I might not even know.
You share genetic code with people over thousands of years ago.
But whatever, same difference.
Same.
Okay. So that's encapsulated within the
The 3, 4.
2, 3, 4, 5 times removed. But my point being, that argument is that, oh no, how can you have a privacy interest in some other dude's DNA? And well, it's because we share the DNA. Like DNA is unlike anything else that we've ever dealt with.
And that's specifically what they're searching in genealogy DNA. It'd be one thing if they
Exactly.
just stayed within your regular individual characteristic profile. That doesn't incorporate you. But
Yeah.
once they start doing the paternal line or the maternal line, well, now they're searching your DNA.
And again, my thing with that is get a goddamn warrant. That's all. Get a goddamn warrant. It's just get a warrant. It's simple.
Right.
All right. So Idaho has taken a somewhat unclear approach to the third-party doctrine. In State versus Mubita, the court permitted protected health records to be provided to the government. In State v. Cluss, the court did the same for billing statements from the utility company. In State v. Donato, the court held that people had no expectation of privacy in trash placed out for pickup. However, the court also held in State v. Thompson that under the Idaho Constitution, citizens do have a right to privacy in who they call, and later extended that to text messages. So Idaho leans pro-citizen. Like they are very much trying to keep the government out of their shit in Idaho, which tracks with everything that I know about Idaho. They don't want the government being able to dig into everything, and if you are, get a warrant. Just go get a warrant. Dig up some probable cause and go get a warrant. You don't get to start by just digging into our privacy without having probable cause. It can't turn into that. We don't want to live in a country where that's the case, because it will affect people that I promise you. Even if you're not a criminal, it will start affecting people. You will have your sister calling you saying, "Oh my God, did I tell you that I just found out the FBI subpoenaed my phone records." And you're gonna be like, "What? What do you mean? What for?" I don't know. It's like, it's going to, if we start allowing the government to dig into us like that, it's going to get ugly really, really fast. All right. So Idaho is not the only jurisdiction to have trouble with third-party doctrine. The United States Supreme Court has refused to apply it to both the search of cell phones and the use of cell phone sites, and that's Carpenter. One of these days, I want to do a live, Valerie, where we kind of go through all of the watershed cases that we hear about all the time. They kind of lay out a lot of the laws that we're talking about in a lot of cases. You'll see Carpenter cited all the time, especially when it relates to anything relating to cell phones and cell phone sites. And you see it because Carpenter is the case from the Supreme Court that dealt with the issue. So that's why you see it cited all the time. So I think it would be cool for us to kind of go through, it'll really be like you guys are sitting in a law school class, like a constitutional law class. It'll be interesting. Maybe a little dry, but interesting. It'll be interesting nonetheless. The issues that the U.S. Supreme Court seemed to take with third-party doctrine in its most recent decisions seem to be the scope of the information available to the government without a warrant if one follows it closely. And do you guys know what they're talking about with the third-party doctrine? That's basically saying that once you turn it's basically saying that once you turn your information over to a third party, you no longer have a privacy interest into it. That it's gone. You've given up your privacy interest. So that's what they're talking about with the third party doctrine. All right, so this concern was fully articulated by Justice Sotomayor in her concurrence in U.S. v. Jones. It is difficult to square this concern with what the court decided in Miller because, as the third-party doctrines defender, Professor Kerr, puts it, in Miller, the checking account created a substitution effect by replacing a transaction that would have included substantial public components with a transaction that would normally occur entirely in private. To see how, imagine a world without banks. If you need to pay for something in this world, you would need to go get the money to do it. You would need to travel to your stash, pick up the money, and then travel to the place where you're making your purchase. If you are the seller, you need to receive the money, take it back to your stash, and then you store it away for safekeeping. There are public parts of the transaction on both sides. So you're out and about, you're out in these streets. You're going to your stash, you're getting your cash, you're making the drive, you're going into the store or the spot, you're picking it up, you're taking it back to your car, you're driving back to your car, or you're driving your car back to your house. So you're out in the public. You're not in private anymore. So checks and other credit instruments eliminate the need to travel. The buyer no longer needs to travel to bring the money to the seller. The seller no longer needs to travel to put the money away. Instead, the seller deposits the checks and the funds from the banks are sent directly to him. The buyer and the seller don't have to move anymore. As the check moves, the funds out of and into their account without them needing to go anywhere. The third party of the checking account makes the entire economic transaction private. And then they cite or incur the case for third-party doctrine. In other words, as Professor Kerr argues, Miller makes public precisely the amount of information Carpenter held private. No doubt the fact that our economy has changed greatly since the 1970s has a part to play in this, but the fact remains that the Miller case and its progeny make little sense in today's world and are irreconcilable with the court's current jurisprudence. In Idaho, on the other hand, the court in Thompson determined with relatively little analysis that Idahoans expected privacy beyond that which the United States Supreme Court had provided for the people they call. See Thompson. So that's what I was talking about. So Supreme Court in the Carpenter case, they basically said, hey, once it goes off to a third party, you've lost your expectation of privacy. So that's on the federal level. Idaho said, no, our citizens in our state are going to have a higher amount of protection. And so they have a difference. As long as the state's giving more protection and not less, it's allowable. A state can never give less protection than the federal government's giving us or the Constitution's giving us. All right. That's why I was saying I want you guys to remember that concept for always, at all times. In essence, the court, without much explanation, held that the dissent in Smith v. Maryland had it right. However, it remains that by adopting the dissent from Smith, the Thompson court adopted a rationale for rejecting the third-party doctrine. From Justice Stewart's dissent, Idaho adopted the notion that what a person does in private does not become public merely by the nature of the act. So the more sweeping is the rationale of Justice Marshall that the court adopted. In my view, whether privacy expectations are legitimate within the meaning of Katz depends not on the risks an individual can be presumed to accept when imparting information to third parties, but on the risks he should be forced to assume in a free and open society. By its terms, the constitutional prohibition of unreasonable searches and seizures assigns to the judiciary some prescriptive responsibility. As Mr. Justice Harlan, who formulated the standard the court applies today, himself recognized, quote, since it is the task of the law to form and project, as well as mirror and reflect, we should not merely recite risks without examining the desirability of saddling them upon society. In making this assessment, courts must evaluate, quote, the intrinsic character of investigative practices with reference to the basic values underlying the Fourth Amendment. California bankers. And for those, quote, extensive intrusions that significantly jeopardize individuals' sense of security, more than self-restraint by law enforcement officials is required, aka a warrant. All right. So it at 7:50. So Marshall dissenting. So despite this, in Donato, the court rejected Justice Marshall's dissent in California v. Greenwood. All the same, the court did not simply join the Greenwood majority. Instead, the court took a middle path set out in the Colorado decision, People v. Hillman. So that decision noted distinctions between garbage and telephone calls in that the latter are open to the public and carry duties of confidentiality, while the former do not. Okay. So as our Supreme Court noted, clearly there is no duty of confidentiality owed by garbage handlers. Included in this analysis, however, is that Colorado had rejected not only pen registers, but that bank records should be obtainable without a warrant. The Colorado court found their cases recognizing expectations of privacy in numbers dialed from a telephone and bank records. This brings us to Mabita. The court in Mabita adopted Miller finding without explanation that nothing in Idaho's jurisprudence would, quote, support a divergence, end quote. Although the court in Mabita analyzes both Donato and Thompson, the court makes no mention of their rationales and instead differentiates them based on whether there can be a finding that greater protection exists due to the, quote, uniqueness of our state, our constitution, and our longstanding jurisprudence, end quote. This holding ignores the holdings in both cases to craft a new one that should have required the Mabita court to reject Miller, given that the longstanding jurisprudence of the only two cases on point in their holdings rejected the simplicity of the third-party doctrine embodied by the Miller holding. Now, do you want to try to decipher that for people, or were you reading something else?
No, I can decipher it. I mean, they're basically just trying to distinguish, where the courts have drawn the line. So they're saying, although in the federal law they say you don't have an expectation of privacy in the number you dial, I Idaho law has, found that you did. So essentially, she's trying to build up to explain basically why Amazon records should fall, way above garbage, and even above the phone calls you dial, which it absolutely should. Um, and basically saying like that this is not just a simple third party um, doctrine analysis.
Right. And like that kind of that distinction between when we put our garbage out to our curb, that you no longer have a expectation of privacy in it. That's where they were talking about, when the garbage man comes and picks up your stuff, like you don't have an expectation that the garbage man's going to protect your privacy, like all your bills that you decide not to shred, or all the murder notes that you put in your garbage and decided not to shred those, all the evidence that you're getting rid of. Like once you put it in the hands of the garbage man, you don't have a continuing expectation of privacy as that's getting transported over the dump. Like you've lost it. Once you brought it out to your curb, it's free game. I say it all the time. Whereas with phone calls and text messages, we have to use a third party. Like we have to use our providers, right? I mean, that's like they have the servers. That's where our information has to get portaled through, and then it ends up on our whoever we're communicating with on their phone. I mean, and they're looking at all of it. Like let's not be delusional. We know through the Patriot Act that they're looking through everything that we have, but I feel like we should have a right to private. Like, I don't want the government reading my text messages to my wife. You kidding? I don't want them in my business like that ever. I don't know many people that do, to be honest with you. It's incredibly intrusive. It's like, it's the it's the double-edged sword of technology. It's like it's given us many wonderful things, but it's also really invaded our lives in a way that's unprecedented. I mean, we've never been on the grid like this in terms of individuals at any point in the existence of humankind ever. Like they are up in our shit. Like you have to specifically decide I'm going off grid to be off grid. Like you have to say, I'm not going to have a cell phone. I'm going straight Luddite. Like I'm just not doing it anymore. Which is it's a huge ask. It's like you can't operate, like society has made it so that you essentially cannot operate anymore without having the technology. I mean, we are so close to being a cashless society that it terrifies me. Like to like everything's going to be, there's not going to be tangible money anymore. Like I'd say 15 years, paper money's gone. If that, it's a scary concept when, like the flip of a switch, if the power grid goes down, everything that we have disappears. Hard pass on that. Like I'm not here for it. So instead, the court in Mobita looked at the Court of Appeals decision about utility bills. Oh, wait. I think I was way past that. That holding, which it adopted, did not simply apply Miller. Instead, the district court had rejected the reasoning of California and Washington cases on the grounds that power usage did not provide any intimate details of Kluss's life, identifying his friends or political and business associates, nor did it provide or complete a, quote, virtual current biography. Finally, the Mobita court notes that one's HIV status is heavily regulated via statute and regulation and may be disclosed to protect the public. So this part of the court's decision, although treated as almost an afterthought, provides the reasoning in the case as to why the defendant could not show a Privacy Act under Article 1, Section 17. After all, if the confidentiality of the information had a disclosure requirement built in, it was necessarily different from phone records. Phone records would not, on the face of them, alert a company to a threat of society. Diseases are different. Thus, although the Mobita court held that Miller controlled, every aspect of the decision belies that holding. Idaho's constitutional exclusionary rule, unlike the federal constitution, protects privacy. I'm moving to Idaho. That's where I'm going. So they have a lot of crime, it seems like, doesn't it? Given the rationales and the holdings of all the cases, even Mobita and Miller has no place in Idaho. This case is not about bank records, but purchase records from an online company. From the standpoint of the Fourth Amendment, one's behavior with Amazon.com can provide a massive amount of information about a person's private life, such as your name, address, searches, and recordings when you speak to the Alexa voice assistant. It knows your orders, content you watch on Prime, your contacts if you upload them, and communications with it via email. Meanwhile, when you use its website, cookie trackers are used to, quote, enhance your shopping experience, end quote, and improve its services, Amazon says. Some of the data is used for personalization. Big tech speak for using your data to improve your online experience, but it can reveal a lot about you. For example, if you just use its online retail site via the app or website, Amazon will collect data such as purchase dates and payment and delivery information. Quote, from this information, Amazon can work out where you work, where you live, how you spend your leisure time, and who your family and friends are, end quote, says Rowena Fielding, director of data protection consultancy, Miss IG Geek. Sorry, I meant to hit the cough button. At the same time, Prime Video and Fire TV information about what you watch and listen to can reveal your politics, your religion, your culture, your economic status, says Fielding. If you use Amazon to store your photos, a facial recognition feature is enabled by default. She says that, quote, Amazon promises not to share facial recognition data with third parties, but it makes no such commitment about other types of photo data, such as geolocation tags, device information, or attributes of people and objects featured in the images, end quote. Amazon Photos does not sell customer information and data to third parties or use content for ad targeting. An Amazon spokesperson says, insisting the feature is for ease of use. You also have the option to turn the feature off in the Amazon Photos app or on the website. Meanwhile, Amazon's Kindle e-reader will collect data such as what you read, when, how fast you read, and what you've highlighted in book genres. See, that's scary as shit. Like, I'm reading Breakfast of Champions by Kurt Vonnegut. I don't need them knowing that. Kurt Vonnegut, man, he knows the secrets. He knew all the secrets back when he wrote that stuff. Go read Breakfast of Champions. Kurt Vonnegut, way ahead of the game. Him and Mark Twain were way ahead of the game. Century earlier, Mark Twain. Okay, so this can reveal a lot about your thoughts, feelings, preferences, and beliefs, says Fielding, pointing out that how often you look up words might indicate how literate you are in a certain language. Smart speakers have been criticized by privacy advocates, and devices such as Amazon's Echo have been known to be activated accidentally. But Amazon says its Echo devices are designed to record, quote, as little audio as possible. Yeah, sure. I mean, does anybody believe that? Does anybody believe that they're not getting it? Like Allie and I we both opened our computers and the little green light was on both of our computers today. I'm like,
I know somebody's watching.
Somebody's watching. It's crazy. It's insane. Like, and all the people are gonna be like, yeah, you got to put tape over that. Like, yeah, use it. What, I'm gonna untape it and tape it every day? Or I just have to get the camera, regular camera, quit using the computer one. Okay. No audio is stored or sent to the cloud unless the device detects the wake word and the audio stream is closed immediately after request is ended, an Amazon spokesperson says. More broadly, Amazon says much of the information it collects is needed to keep its products working properly. An Amazon spokesperson says the company is, quote, thoughtful about the information we collect. We're so thoughtful. How would you know? like how would some spokesperson know what they're doing with the data? You think that a spokesperson that works for one of these monster tech company has any idea what they're really doing with the data?
No, she knows what she's told.
You tell them, babe. You tell them. All right, but it can add up to a lot of data. In 2020, a BBC investigation showed how every motion detected by its Ring doorbells and each interaction with the app is stored, including the model of phone or tablet and mobile network used. Ring can share your data, stored data with law enforcement if you give your consent or if a warrant is issued. So
I just want to note that all of these arguments would be extremely compelling if, in fact, the data at issue that they're using, that they accessed, that they're seeking to use falls into all of these categories. You know, at the end of the day, I think what we're going to have is just his purchases, you know, which is why it was very important for her to distinguish that Miller case and say that even in the case where they gave the HIV health data, you know, like that's very private information.
but
And they
there is
claimed,
a built-in
I get it,
disclosure with
I get it. So, and that they claimed they relied on Miller, that they really didn't rely on Miller because, like Bob just said, there was a built-in disclosure and they had other examples of it being significant to the public health and things like that. But in the actual argument, they were saying this follows with Miller. And if they can extend that to Miller, then she's predicting I'm going to lose on this under Miller. So that's why there was so much significance in giving the reasonings that the courts gave. And although, yes, they said it was consistent with Miller, they had to rely on all these other aspects in order to get there. So I don't know, because you're not just talking about one receipt, like going down to a store and tracking down a receipt. I mean, if Amazon's where you do your shopping, like she laid out, they've got every purchase that you've made, everyone you have sent something to, anywhere you visited where you had something sent to you, um, even if they don't have all that, you know, some of that other data at issue. And I guess we won't know until the hearing whether they do, and I don't even know if at the hearing we'll find out.
I don't know either. They need to unseal shit now. It's time to unseal it. I'm tired of everything being sealed in cases that we're all following. I'm over it.
Well, at the end of the day, like, I haven't been following Kohberger all that much. I know, like, very little. So, I don't
You
know.
were
Did it
following it pretty heavily with me early.
Yeah, I do remember that, but I don't know, like, anything that's come out since. So
You're
I
the
just
one who hooked me up with Nate Pepino, for God's sakes. The
uh,
great Nate Pepino who sends me everything. Until he
so
didn't, like Nate, I think got a new gig. So now Nate's not like now I'm not getting the stuff.
all right, my point being that whether he didn't or, he did it or didn't do it, um, now I forget what I was saying, but it was something about the oh, with regards to the sheath, if it's his, I mean, if that's his DNA, it's his, and either there's an excuse for why it's there, some reason for how it got there, you know, or there isn't. It doesn't necessarily mean that he did it, but I don't know if they challenging the DNA as well? Are they saying it wasn't his, or are they saying there's a reason it was
Well,
there?
she's saying it's touch DNA, which is, in her estimation, completely useless.
Well,
That could
except
have been
someone's had to, it's like on the on the clip thing. I
on a
mean, that's
snap. On the
right.
snap.
That's kind of like that's where you press your finger.
Well, yeah, but I mean, it's still transfer DNA. I mean, if he was our client, would you be sitting there saying that?
No, but I'm yeah, no, I'd
Right.
be making all these very same arguments. I'm just saying, like,
Right. Look, at the end of the day, the touch DNA, as much as people want to say it's hot garbage, is going to be very much the same thing as the unspent casing
no,
was
no,
for
no,
the
no, no. It's totally different because the touch DNA, assuming they have a full profile, all they know is that someone that came in contact with him came in contact with it, right? But that's if they have a full profile, there's no debate over that. The ballistic thing was crap. It didn't tell you what gun it was. It couldn't tell you what gun it was. She couldn't do the same test. That's completely different, science. Now,
Well,
it's
it's completely different science, but it's the exact same concept because somebody like eh, like maybe that like there's just a way that his DNA got on that thing. Maybe he picked it up like he was actually at a party and he said, "Oh, like whose cool sheath is this, man?" And
right.
he
That's
like
what I'm
picked it up.
saying.
I mean, there's it's the same thing. Like
Somebody's yelling
obviously
up here,
different
it's
science.
not a full profile, and if that's the case, like, it's what I'm saying, like, I haven't been on top, I don't know where things came out, but if they're, you
Well,
know
we don't know what kind of I don't know why anybody's saying definitively whether it's a full profile or not. Like we don't know that. We know that it's not a mixed profile.
they
It's a
said it's a
sing
single
it's
source.
we know that. I don't know how anybody is saying whether or not they
Well, they
know it's a
claim that
full
it's a single source. I mean, you just I
well,
guess you'd have
they claim well, they're claiming it's a single source, right? But
right.
like we that's all we know. I don't know how anybody's out there saying that they don't know if it's of like full profile. We won't know that until we see the goddamn profile. Unless somebody got a hold of it. Somebody
Or
get
there's
a hold
been
of the profile?
motions that we don't know about
No, it's
that
all sealed. It's all sealed. All of it's sealed. All right, so given the sheer amount of information, wait, see, I always forget where I'm at. Okay, so given the sheer amount of information Amazon retains, the Fourth Amendment, as understood in Carpenter, requires a warrant before the government can access such information. Here. So, as for Idaho, there can be no doubt that Article 1, Section 17 requires a warrant before law enforcement can access Idahoans' online records. Amazon.com, like phone companies, is heavily regulated and guarantees its customers' privacy. See Amazon's privacy notice. It is not garbage one leaves out on the street where snoops can find it, nor is it HIV information that society has a stake in knowing. For these reasons, the court should find a warrant is required to access such information. Thus, the FBI's subpoena gathering the information from Mr. Kohberger's account violated his rights, and its results must be suppressed. So that was the argument for one. And I think it's a strong argument. I do, especially under Idaho law. I mean, if they have a higher standard, if they're saying, if their law is that you need You need a warrant to get those kind of records. You can't use the information that you got from a subpoena where you got the information that you then turn around. But she doesn't know. She's sitting here because they haven't turned over the subpoenas. So she's sitting here like in the dark for some reason. So you have to ask yourself, from the perspective of the government, what are you hiding? Why aren't you just turning the subpoenas over? It's just like the shit they were doing with the IGG. They wouldn't turn it over. They're like, nah, we're not going to use it at trial. Why do you need to see it? And she's like, because it was like the basis of your warrant. Like all of these motions and memorandums are why I needed to see it. So I can see how you developed your probable cause to get your arrest warrant, because it was based primarily on that sheath and that DNA that you're claiming that you have a match for. And I want to see your work. Show your work. Prove it. So for these reasons, the court should find a warrant is required to access such information. Oh, sorry, we're at 2. Okay, so 2, the affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. The Fourth Amendment states unambiguously that, quote, no warrant shall issue but upon probable cause, supported by oath of affirmation, and particularly describing the place to be searched and the persons or things to be seized. Probable cause exists when, given all the circumstances set forth in the affidavit, quote, there is a fair probability that contraband or evidence of a crime will be found, and this is italicized for emphasis, in a particular place. That's Illinois v. Gates. It's another one of those watershed cases I was talking about. Quote, for a search warrant to be valid, the judge issuing the search warrant or issuing the warrant must rely on an affidavit or affidavits sworn to before the judge or by testimony under oath and recorded that established the grounds for issuing the warrant. Any discrepancy between the items for which there was probable cause and their description in the search warrant requires suppression. Right?
Yeah, for sure.
That's specificity. That's what we're always talking about, the specificity. It is clear that the issuing magistrate himself, if he is to fulfill the constitutionality or constitutionally mandated function of interposing an independent intelligence between the law enforcement officer and the citizen, must actually, and in fact, draw the inferences from the evidence presented to him. It is for this reason, and these are all quotes from cases, y'all. So
And just so you know, I mixed up the one that's repeated. It's this one. It's this one that talks about how do you attack the warrant, what challenges a defendant can raise, that omissions can amount to materiality.
Right. So it is for this reason the courts have insisted that the full facts from which inferences might be drawn and information necessary to determine their reliability be placed before the issuing magistrate. I mean, that makes sense, right? To everybody, like we want that there's got to be, you just don't want them going in there getting warrants on bullshit. Like they have to show their work. They have to show what their probable cause is. It can't just be bold statements, reckless statements, bald statements that have no backing. That, we need more. We need to be able to see more. So finally, a criminal defendant may challenge the veracity of an affidavit used to obtain a search warrant. Upon a preliminary showing of a warrant's deficiency, the defendant must prove, by a preponderance of the evidence, quote, that intentional or reckless falsehoods were included in the warrant affidavit and were material to the magistrate's finding of probable cause, or that material exculpatory information was deliberately or recklessly omitted. An omission of exculpatory facts is material only if there is a substantial probability that, had the omitted information been presented, it would have altered the magistrate's determination of probable cause. So whether an omission was intentional or reckless might be inferred in part from the relative importance of the information and its exculpatory power. So that's a good one to end that on. Whether an omission was intentional or reckless might be inferred in part from the relative importance of the information and its exculpatory power. It's a powerful statement. She's saying like, look, you could tell if they kept this fact out from you, Judge, based on how powerful it is. And from that, you can tell if it was intentional or reckless. You got to use some inference there. Got to use some common sense. So in this case, law enforcement either intentionally or recklessly omitted exculpatory evidence as to almost every facet of its affidavit for this warrant. Thus, it will require suppression. The proffer required for the and this is what's driving Allison crazy. Like what? Like what? Like she wants to know. She wants the details. We all want the details. Tell us what. So what are all the different things that they omitted or recklessly?
Well, not even that,
out?
because I understand, hey, you gotta look at your text. Sorry, I got a family household thing I gotta resolve right now. So it's not even just, yeah, obviously I would like to know what they omitted and like some details. But my real issue is trying to apply the analysis she gave to the data. For this one, I guess it sounds like the only data at issue um, is the sales through Amazon, but there's just no specificity about how many years of data did they look through and where did they find this data. And because the more stuff they had to search, the more it might rise to the level of a Fourth Amendment violation. But yeah, I would also obviously love to know all these details.
This should have been dealt with during the day, babe, not while we're on a live.
I understand.
Yeah. Yes. The answer to your question is yes.
All right, but today's the deadline.
This should have been dealt with today. I don't know why you're dealing with it with me on a live right now. I can't deal with this. Like I'm trying to read some heavy duty case law here. I don't even know.
I mean, he doesn't even think it'll come to that, but it's possible.
I don't know. All right. All right. So let's see. I forgot where I was. So was I here in this case? Law enforcement either I intentionally or recklessly omitted exculpatory evidence as to almost every facet of its affidavit for this warrant. Thus, it will require suppression. The proffer required for a Frank's hearing is filed contemporaneously under seal. The proffer asserted applies here. In additional, I think it's supposed to be in addition to the proffer, the affidavit for the Amazon search warrant did not explain to the magistrate that federal agents had been talking to Amazon and issuing subpoenas, and that was how that they gathered the information for the affidavit. Mowry intentionally failed to disclose the illegal means by which the investigators had located the Amazon information. That is a real problem for the state. Like in Idaho. Like it seems that the law is set there that for that type of shit that you need a warrant. And they went and sent all these subpoenas off. And that's how they obtained the information that they were able to go and get the warrant with.
Yeah, but we don't even know what they wrote in the affidavit. Like, we don't know what part of the information they relied on. Was it just he has an account with Amazon, this is his account number, and that's his address? Or was it actual I don't know.
I don't know. I think we have a pretty good idea. It sounds like they found some shit that she didn't want them finding. Like, is she suppressing him buying like Charmin?
Well, no, clearly she thinks that it's, inculpatory.
Right. So obviously there's some
No, but I
inculpatory shit in
mean,
there.
I don't know if they actually had already gotten everything and then the warrant was like backup.
Okay, here's what I'm gonna do. I'm gonna point you back to this sentence right here. Whether an omission was intentional or reckless might be inferred in part from the relative importance of the information and its in exculpatory power. So like that's what I'm saying. Like the fact that they haven't turned the subpoenas over speaks volumes to me.
Yeah, no, me too, for sure.
I mean, if like what are they trying to do? Are they trying to like go back and like change history? They're going back back to the future, and they're trying to like say, okay, well, we really fucked this one up, man. Like we've got to do something with these subpoenas. We can't have this appear in the information that Amazon gave us. But I mean, Amazon's lawyers, like, where were they at in this whole thing?
I don't
Like,
know. Why is Amazon turning over people's
right? Why? Like,
information
what are
just
they doing?
a
Like the
subpoena?
cops calling, they're like, here you go. It's like as much as I can't stand Apple, at least they like fight to
I mean,
protect
I
our
can write a
privacy rights.
subpoena, so if they can get it, I can get it.
Exactly.
Ugh.
Like the subpoena power of the court is not a warrant. That's what I was trying to explain to people. It's a very different document.
They don't even need
Well,
an actual judge anymore to sign off them, just a lawyer or a cop or whoever.
yeah. All right. So, and then 3, the affidavit submitted in support of the application for the issued search warrant included information that must be excised. Where information in a warrant was obtained via a violation of the Constitution, Idaho courts excise that information. Okay. So, A, all information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. Mr. Kohberger has argued in a separate motion that IGG in this matter was done in violation of the Constitution. Additionally, he argues that there would be no investigation into him without the original constitutional violation. It is not that the results of the IGG sped up the investigation. Instead, they focused the investigation on Mr. Kohberger, a person whose only connection to the case was his mode of transportation and the shape of his eyebrows, 2 identifications of little to no value. As the Idaho Supreme Court has explained, while the initial burden in showing a factual nexus between the illegality and the evidence, the state must show it would have discovered it anyway. The state cannot make the showing. Without IGG, there is no case. There's no request for his phone records. There's surveillance of his parents' home. No DNA taken from the garbage on his driveway in a gated community under a garbage collection ordinance. Because the IGG analysis is the origin of this matter, everything in the affidavit should be excised. That's what I'm saying. That's what her argument is. It's like, and she's just waiting to have this IGG thing hashed out, but it
Yeah, but
all
she's
goes
gotta
back
put
to that.
other forks in the fire in case the IGG loses, so
Yeah, but like that fork is the main fork in these
well, yeah, she's
suppression
using
motions.
the right, that's what the Amazon like, all the other things that she's raising, and then she's circling it back to, and also don't forget all the IGG stuff.
But she's saying that none of this shit exists
I get it.
absent the IGG stuff.
I get it,
We're
I'm
not
just saying she's adding other, backup to that, like, well, the police didn't tell the judge that they were already talking to Amazon, and they already got some information from Amazon illegally, so, um, so you've got that, and that the data itself is um, you know, subject to a warrant and not a subpoena in the first place.
Yeah. Um,
You want me to read the next one?
yeah, you're gonna read the second one. All right. So, but like before we jump to it, so I don't know if these were filed in the order that she wrote them, but typically lawyers will write their strongest motions first. Typically. It's like when you're talking about like in your actual motion itself, you're typically writing your strongest arguments first, and then they get weaker as you progress. Like to me, this based on Idaho law, I think that they're in deep, deep trouble. Short of them providing a subpoena that says, "Look, we didn't get anything. We didn't get anything from this. Like, this is it. We got his name, where he lives. That's it. We don't have anything." But we know that they received what he buys, his purchase history. We know that they received that. I think this warrant has legs. I'm going to vote that this one has legs.
This motion.
Yeah, what I call it, this warrant.
Yeah.
Okay. So B, information gathered about Mr. Kohberger via previous invalid warrants must also be excised. Separately, the information gathered via the various other warrants should be excised for the reasons set out in the other motions to suppress. So conclusion, Mr. Kohberger requests this court suppress all evidence obtained by the police via the subpoenas and the warrants that permitted them to search his Amazon account. As explained above, a warrant was required to search his account, and the warrants used lacked probable cause is written, given its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate to draw its own conclusions. And because the warrant omitted exculpatory information and information that put into question the reliability of the facts upon which it relies, and finally, because the affidavit relied on evidence gained in violation of the Constitution, all in violation of the Fourth Amendment and Article 1, Section 17. All right. So that's the first one down. Okay, so let's see. Is there
I'm gonna
one
pull
that
it up
you
on
like?
my side. I mean,
You could
I think
do whatever one you want next. Did you like anyone in particular?
I read the affidavit. Which one is this for? Oh, his Apple account. I can do this
You
one.
could do whatever one you want. I like the ones a lot about the search at the parents' house. Like those are really interesting to me.
I don't know if I read that one yet. You want me to switch over to that one?
Do you have it? Oh yeah, you have them all, right?
Oh yeah. I just have to.
Yeah, the iClouds, because the iClouds very similar argument. Search of his person, a pen trap and trace device.
This was this person in Pennsylvania.
Yeah.
I have that one open. You want me to do that one, or you want me to look?
No, do the one with the house, the parents' home.
All right.
They're trying to suppress evidence and his statements made after arrest.
Oh, okay. I didn't read that one yet, so let me grab it.
Okay. It should be right after his person. Or no, it's right after the Elantra. So his person.
Oh, search warrant for his person.
And then the Elantra, and then his parents' house.
It says redacted. Yep.
Yes.
Yeah, this is it.
Yeah,
okay.
All right. So you want to pull it up for yourself?
Yeah, I'll do it.
All right. I'll pull it down.
Or I can blow it up a little bit more. Let's see. Oh no, I can't. Okay.
Hey, Ken.
Is that about it, or I have room to go more?
Why does yours look weird?
What do you mean?
Okay. Can you make it like, why is you have the little toolbar?
Yeah, I've never been able to figure out how to get rid of that thing.
Really?
Yeah,
Oh.
it's annoying as shit.
Maybe change your view. Like I think
no matter where I put it, it's still there.
Well, like mine's like right in the middle of the page, and I've got like my margins, like that toolbar is way over to the sides. Like mine looks like it's got like the actual like page breaks. I don't know, whatever.
I switched to read mode. Is that better? Oh, I moved it to the bottom when I put it in read mode.
Oh yeah, that's better.
Okay.
Yeah.
Okay, comes now Kohberger buying through his lawyers, and this is a motion to suppress all evidence gathered by law enforcement as a result of the entry into and search of Mr. Kohberger's parents' home in Albrightsville, Pennsylvania, including statements made after the arrest. Now, in Illinois, those two things should be separated out because the state has the burden on a motion to suppress statements, but let's I guess that's neither here nor there. The motion and documents in support of a Frank's hearing are hereby incorporated into this memorandum. The proffer with supportive documents regarding Franks are filed under seal. For that reason, they are not set forth in detail. So here are the issues. This court should apply Idaho's exclusionary rule and law to this search. Mr. Kohberger's has standing to challenge the search of his parents' home. That's going to be an interesting issue. Pennsylvania law enforcement violated Mr. Kohberger's Fourth Amendment rights by entering and searching his parents' home without a valid local warrant. That's a good point. The Idaho search warrant could not have given police in Pennsylvania the authority to open the home, enter the home. That is also true. Federal and Pennsylvania law enforcement violated Kohberger's Idaho and Pennsylvania constitutional rights by not knocking and announcing their presence and presenting Mr. Kohberger with the opportunity to surrender. I don't know what the remedy is for that when you're dealing with an arrest and not a search, but we are about to find out together. The
Yes.
affidavit submitted in support of this application for the issued search warrant recklessly or intentionally omitted material information. The affidavit for the search warrant included information that must be excised, and that would be all information in the affidavit that was gathered because of law enforcement's unconstitutional use of genetic genealogy, and thus nothing in the warrant should remain. And the information about the client's location taken from his phone must also be excised due to being gathered from an invalid warrant. Now, that's also true. Talking about somebody's real-time movements. Statements after arrest are either fruit of the poisonous tree from the illegal arrest or should be suppressed as a Miranda violation. All right. Well, this is an interesting one. How many pages is this? I can't see the pages
400.
in read view.
It's 18.
All right. Well, don't forget to respond to my text while I'm reading. You have time to think. Due to the haphazard way in which law enforcement has kept and disclosed records from this matter, the following are facts relating to obtaining the search warrant for the parents' home in Chestnut Hill Township. On December 28th, 2022, Trooper Larry of Pennsylvania State Police became aware of the objective of arresting Mr. Kohberger via Moscow Police Corporal Payne. On the 29th at 4:44 p.m. All right, so I guess that's 1:44. Oh, but okay. So 4:44 Eastern Time, a magistrate in Pennsylvania issued a search warrant for the home in Chestnut Hill, Monroe County, for the parents, Exhibit A. On December 29th, 2022 at 2:22 p.m., and now they went back to PDT time instead of Eastern time. The magistrate in this matter signed an arrest warrant for Mr. Kohberger in Latay County. The affidavit for the warrant was signed by Moscow Police Department Sergeant.
All right, so it's Latah and Moscow.
Okay.
Moscow and
Moscow.
Latah.
I do remember it was
Not
Moscow.
Moscow,
Yeah.
not
Right,
like
right.
Russia.
When I'm reading it, I
Moscow
forgot Moscow.
and
And we said
Latah.
Latah. So the arrest warrant was issued.
Because people will like get all snipey in the comments.
Okay. And now I take it back because if they had a valid arrest warrant, no, right. They could have used that arrest warrant to get a search warrant to enter the home. Otherwise, if they found him outside of the home. All right. So let's keep moving. Where did you say Latah, right?
Latah, yeah.
The basic facts.
What did you say? It was hilarious. It was something.
Latay, I think, or
Latay.
Latah.
That was like Chickapay, Twain in the wind.
Latah is what I thought, and then I
Twain
was
in
like
the wind.
Latay, and then like I don't know. Now you got me. Now I'm going to say it right again. What is it?
Chickapay, Twain in the wind.
What is it again?
Latah.
Latah. Right. Yeah, that's what it looks like actually. Now,
Yeah.
now that I see it again. Latah. All right. The basic facts Blaker used to support the search were: 1, next to the body of Madison Mogan was a tan leather knife sheath. The Idaho State Lab later located a single source of male DNA on the button snap of the knife sheath. Footage from the King Road neighborhood showed what the police suspect was the vehicle of the killer. The white sedan lacked a front license plate. A vehicle specialist decided based on footage that the vehicle was a 2011 to 2016 Hyundai Elantra.
Was
The
that like
vehicle
Harshman, the voice specialist? I
No,
wish
but you know what? I have to say, it's not like they went out with an agenda to unless he, like to identify this guy's car. They weren't looking for, you know,
What do you
they
mean
weren't
initially when they were creeping around in the parking lot at WSU at Washington
No, I
State?
mean, like, when he first watched the video to tell them what kinda car to be on the lookout for. So, a vehicle matching that description was
Yeah, but they
spotted.
screwed up the year initially.
Yeah, I
Like they
know. I get it. Once they try to make it fit with Kohberger, then they start I hear you.
right.
Um All right, a vehicle matching that description was spotted via surveillance in Pullman. It was later discovered that Mr. Kohberger drives a 2015 Hyundai Elantra and that he lived not far from the last place a white sedan was seen driving in Pullman over an hour later. That same specialist indicated the car seen in Pullman was a 2014 to 2016 Hyundai Elantra. Witness Dylan, is it Mortensen?
Mhm.
Had indicated the height of the person she saw at the time of the attack was between 5'10" and 6 foot, a very safe bet and guess for it to fit the description of any given man, except of course Bridge Guy. So, um, and they had bushy eyebrows. Police determined Mr. Kohberger fit that description. I mean, I think Bob fits that description.
I don't have bushy eyebrows. I wish I had bushy
I
eyebrows.
mean, records from an August 21st, 2022 traffic stop showed Mr. Kohberger was the driver of a white 2015 Hyundai Elantra with Pennsylvania plates lacking a front plate. It it also showed that he had phone number 509-592 whatever
Hold
address.
on, I'm calling it right now.
He noted
Hello, Brian?
investigators.
Is that you?
I mean, there's probably a ton of people calling it right now.
Yeah, you think?
He noted investigators learned that this was an AT&T number. Mr. Kohberger had changed his vehicle registration to Washington on November 18th, 2022.
Did you ever
Well,
call 8677
no,
309? What? Wait,
8675
yeah,
309.
309. Did you ever call it? They actually put like a recording on that. Do you remember that? Like, so when people like when that song came out, they actually put a recording. Like, hi, this is Rick Springfield. I swear to God.
I do not remember that.
Yeah, it's like a real thing. I was like, what? All right, but I digress. Sorry. This is
Yes,
serious
yes.
business. This is serious business.
Um, Mr. Kohberger had changed his vehicle from registration to Washington in November. Cell tower records did show Mr. Kohberger was in Moscow at the time of the murders. In law enforcement's expertise, however,
Experience.
all right, I'm sorry. I'm sorry. Cell towers did not show Mr. Kohberger was in Moscow at the time of the murders. In law enforcement's experience, however, people committing crimes typically turn off their phones. Historical cell site location information was obtained and given to a cellular analyst survey team cast with the FBI. That team determined that on November 13th, 2022 at approximately 2:42 a.m. that Mr. Kohberger's phone was utilizing cellular resources that provided coverage to his apartment in Pullman, Washington. They then support the idea that he left his apartment and went south. They then supported the phone being off. They then support at 4:48 a.m. that the phone is south of Moscow. I don't know, ID near in Idaho near Blaine, Blaine, Idaho. The phone utilizes resources that make their way back to Pullman, coinciding with the white Elantra. Now it's the white Elantra seen on some surveillance there. The phone utilizes resources that make their way back to Pullman, coinciding with a white Elantra seen on some surveillance there. A similar data showing occurs at approximately 9 a.m. with a trip to Moscow and returning around 9:32 a.m. That's that same team determined Mr. Kohberger had been to Moscow on at least 12 occasions prior to the event and that he came into the area the morning following the murders. However, law enforcement, without explanation, indicated it did not believe that final trip ever occurred.
I
Now
don't get
remember
that.
this. It was like
Yeah.
all this data is right and this data is right, but hey, they got this one wrong and sometimes that happens. Remember we were reading this and I was like, "Okay, can we throw it all out now? You can't just pick the one that's wrong." And yeah, they clearly know something that we don't, obviously, and it seems she doesn't, as to why they are trying to. I think it's because they know he was elsewhere.
Yeah, and that final trip was very damning. Like, that was the one, like, he's going back to, like, get the sheath or, it's like it causes you to speculate all kinds of things. Like, or he's coming back to see if they've like, the cops are there yet or whatever, whatever the case may be. He's going to check out his handiwork. I mean, it's a very inculpatory drive-by of the residents for them to be like, "Oh, just kidding about that last one."
Right. um Whoops, sorry. Okay, Pennsylvania agents seized garbage at Mr. Kohberger's parents' residence and found DNA it determined was likely the father of the suspect DNA found on the sheath. At 2:43 p.m. So what's PDT? Pacific daytime? No,
What?
PDT. Is that Pacific daytime?
Yeah, well, it's Pacific time. Yeah.
Okay, because I thought I didn't know if they were like mountain time or strict. Okay. On December 29th, 2022, a criminal complaint and probable cause order were filed in this matter at 10 p.m., and that's 7 p.m. Pacific time. Pennsylvania SWAT team began preparations to arrest Mr. Kohberger. Despite weeks of constant FBI surveillance, Pennsylvania law enforcement did their own surveillance starting at 11:15 p.m. Eastern time. And despite the fact that weeks of constant FBI surveillance showed Mr. Kohberger was unarmed and tended to go for runs around his parents' neighborhood, meaning he's going to be outside of the house, so he could have waited, police decided that in the dead of night, within his parents' home, was the best way to make an arrest. And I'm sure you will see here that they're not
How do they
supposed
know
to.
he wasn't armed?
I mean, she's just saying, I guess, that they saw him, but yeah,
Running, like jogging,
yeah. But you're right. I mean, they can't really prove that he doesn't have a um
big knife.
or a weapon of any sort. On December 30th at 1:14 a.m., Pennsylvania SWAT raided Mr. Kohberger's parents' home. She should stop calling it the parents' home. Well, I guess if he was sleeping there multiple times by then, right? He was
Well, it was his
overnight.
parents' home.
Well, I know, but as far as as far as him having standing to assert a Fourth Amendment violation.
Oh, well,
But I
yeah,
think,
that's interesting. Can you, like, if our college student comes home, even though they have their own residence with
yeah,
their
I
name on
think
the
they're
lease?
domiciled here. This is their house. Yeah. And anytime you're an overnight
You're a
guest.
graduate student, though, at that point. Like, I don't like
But is that where is that where he lived? Is that where he kept his license? Is that where but if he was an overnight guest, he's got some rights as well. And obviously she's getting into that because part of this uh, memorandum addresses standing. Because typically, so let's say that I'm over at my friend's house and the police come in and they tear up the entire house, they destroy everything, they like are beating people up, doing all sorts of shit, but they're arresting me. I don't get to complain that they violated the Fourth Amendment rights of the people whose home that they came in and entered without a warrant. no matter what they do to all those people. It's like, okay, it didn't happen to you. So, on December 30th, okay, they raided the home. During the raid, there you go. Law enforcement broke the front door to the home, shattered the sliding glass door of the basement, held the entire family at gunpoint, and seized Mr. Kohberger. Mr. Kohberger made statements to his arresting officer. He was transported to a police station in Stroudsburg, Pennsylvania, and made statements during transport. At the station, Mr. Kohberger was processed, during which police collected information about his person. Finally, during interrogation, before requesting an attorney, Mr. Kohberger made statements to interrogators from the Idaho State Police and the Moscow Police Department. At 4 a.m. on December 30th, Pennsylvania State Police filed a criminal complaint against Mr. Kohberger. So don't tell me we're getting another motion about statements being made that they're seeking to exclude without saying what the statements are. Is that what I'm about to get through this whole motion and never know, Bay?
Probably.
The first question should this court should apply Idaho's exclusionary rule and law to this search. Okay, it's not a search, it's an arrest.
Well, it was a search and an arrest.
Did they actually search the house?
Yeah. I think so.
I knew that they searched the garbage. I didn't know that they actually searched inside the home.
Yeah,
Okay.
they searched the home. That's where they found like the gloves and shit.
Oh,
Like there was some like I don't know if it's true or not, but like they claimed when they came in, he was sitting at the kitchen table sorting garbage with like blue latex gloves on. Yeah.
Well, that's highly suspicious.
Highly suspicious. Boom, boom. Highly suspicious of you.
And that is my morning jacket for anyone who cares. Unlike the issue, the first question this court must decide is whether there's a conflict of the laws in this matter, whether Idaho law or Pennsylvania law controls validity of the search for Mr. Kohberger's parents' home and the necessary relief. Unlike the issue of arrest warrants, cases involving multi-state investigations have produced far less case law. In fact, the defense could not find a precise case on point in the state of Idaho. No, but I'm certain you could have found one in Pennsylvania. Bob and I did practice in Pennsylvania.
We did indeed. We did indeed.
The issue, however, has received some attention in academia. Professor Kerr argued in his article for the Harvard Law Review that the jurisdiction where the crime occurred should control how the investigation is done, but the states or the federal government should provide some form of authorization to each other to participate in each other's criminal investigations. As it stands, there are at least 5 different approaches to this increasingly common situation. Fortunately for this court, Idaho and Pennsylvania do not differ in their approaches to enforcement of the Fourth Amendment analog provisions. What? Both do not accept the good faith exception. I got to think about that, but she's got a case here. So, and she cites State v. Guzman for that proposition in Idaho and Commonwealth v. Edmonds for that proposition in Pennsylvania.
That's what I was telling you. I got sucked into the Guzman case. I was reading it for like 45 minutes. I was reading the Idaho case about Guzman. It was a weed bust. It was like there was a CI that kept calling in a tip. Dude's like, yeah, this guy's got 200 pounds of weed inside his house. And they ended up, which this argument she makes, and
I just didn't know if you were going to tell us a little more about Guzman or if you want me to just continue.
No, keep going. Like the
Okay.
Guzman thing was interesting though.
This the court can likely afford to leave as an open question which forum's exclusionary rule applies. However, it is also clear from the grounding of the exclusionary rule in Article 1, Section 17, that's in Idaho, that the evidence violated the Constitution and must be excluded. Thus, Mr. Kohberger argues that the Idaho Constitution's exclusionary rule must apply, as its basis lies not only in deterring police misconduct, but because the exclusion is constitutionally mandated and judicial integrity demands it. However, it remains to be decided whether the actions of the FBI and Pennsylvania state troopers should be judged by the protections of Article 1, Section 17, or its analogs. It is not clear at all. It is not at all clear that whether a search should be judged by Idaho standards of reasonableness or that of Pennsylvania, or in the case of the FBI, by the Fourth Amendment. And that's always been an issue for me. In a lot of our drug cases, you've got, and a lot of it doesn't even have to be drug cases, but joint task force where the feds are coming in and they're doing whatever the hell they want because um but then they decide to hand it over to the state. And I'm like, all right, well, the feds knew that they screwed something up. Now they're trying to get the state to prosecute. But now you've got, the feds getting warrants and subpoenas issued by judges on different grounds than the state law, might require. And, anytime you want to make an argument that your state offers more rights than the Constitution, it's hard unless the state has come straight out and say it. And it seems like maybe Idaho has. I don't know that Pennsylvania has. But I mean, I haven't practiced there in a really long time. So as noted, Professor Kerr would have Idaho's reasonableness apply in that the FBI and the Pennsylvania state troopers were acting under its authorization. This approach would also mesh with older cases, such as U.S. versus D. Ray, looking to the law of the state where the defendant was arrested in absence of federal law permitting the arrest by a federal agent for a federal violation. She also cites Johnson v. U.S., a 1948 case. It also goes along with the legal framework of agency. There, she's talking about restatement of torts. So you're talking about the civil law and how you say, well, since Idaho police asked you guys to help them, you're an extension of Idaho. Idaho law applies. But then you got to deal with, well, if they're exercising their authority in the manner that they, are afforded under their laws, should the evidence still be excluded? Well, first of all, Pennsylvania can't go in and search anything. They're trying to say that's a search incident to an arrest. They went into a house to I mean, I'm assuming maybe that's what they're arguing, is that it's a search incident to arrest. You got to be looking for something like very outwardly obvious, or maybe she's going to get into the to get into some other doctrines that here's we'll see what they did, because I don't really get it. But it is definitely a problem when you've got people trying to use, well, all right, let the feds do it. They're going to get a warrant faster for this, or they'll get something issued we couldn't get done in state court, and then they want to get it in, get it in the state level. So this is not an unusual argument. We've made similar type arguments on a litany of different cases, but it comes into play a lot in drug cases. In this matter, Idaho authorities requested the assistance of the FBI and the Pennsylvania State Police. Mr. Kohberger was not under investigation for violating Pennsylvania or federal law. Thus, the court should require to apply Idaho's search and seizure law to their actions in Pennsylvania. However, this approach has its detractors. McClin argues that when the CITES officer is performing the search, they should only be held to upholding their own laws. While that position has merit, as it does not require the CITES officer to get a rundown of the differences between their laws and the trial state's laws, it remains that the Idaho Constitution is not merely concerned with deterrence to officers who misbehave, again, citing Guzman. Moreover, it is of concern that such a rule would permit forum shopping. That's exactly what we were just, talking about a moment ago. That, then they're like, "All right, you do it here, feds, because you're going to have an easier time." Or, it's like, "All right, which state are we going to have an easier time, getting a warrant?" So that's what they mean when they say um, forum shopping. After all, if Idaho's law enforcement may take advantage of a laxer restrictions in a different state, they may simply pause their investigation until their suspect is in that new jurisdiction. Or in the case of the FBI, state law enforcement could, at any point, even within Idaho, call upon federal agents with far laxer rules for the Fourth Amendment. Finally, it must be said that there is very little daylight between the Idaho Constitution and the Pennsylvania Constitution. Both apply exclusion to the failure to knock and announce. Yeah, and that's why they put in all those facts about they broke the door, they went in the middle of the night. They're not supposed to be doing all of that. But I'm going to be surprised if they were just going in on a search warrant or not. But in any
I mean,
event,
that's how Breonna Taylor got murdered by the cops.
yeah, knocking in on just barging their way into the wrong house. Her and many others. If anything, Pennsylvania appears to have stricter warrant requirements for particularity. I mean, I bet they have stricter knock and announce too, given issues in Philadelphia. But Mr. Kohberger has standing to challenge the search of his parents' home. Mr. Kohberger grew up in his parents' home, and at the time of the entry and the search, he was staying there for winter break as an overnight guest. He undoubtedly has standing to challenge the search in this case. Moreover, the court in Olson, and that's Minnesota v. Olson, clearly had a situation just like this case in mind. That the guest of a host who has ultimate control of the house is not inconsistent with the guest having a legitimate expectation of privacy. The house guest is there with the permission of the host, who is willing to share his house and his privacy with the guest. It is unlikely that the guest will be confined to a restricted area of the house, and when the host is away or asleep, the guest will have a measure of control over the premises. The host may admit or exclude from the house as he prefers, but it is unlikely that he will admit someone who wants to see or meet with the guest over objection of the guest. On the other hand, few house guests will invite others to visit them while they are guests without consulting their hosts. But the latter, who have the authority to exclude despite the wishes of the guest, will often be accommodating. The point is that the hosts will more likely than not respect the privacy interest of their guests, who are entitled to a legitimate expectation of privacy, despite the fact that they have no legal interest in the premises and do not have a legal authority to determine who may or may not enter. If the untrammeled power to admit and exclude were essential to the Fourth Amendment protection, and an adult daughter temporarily living in the home of her parents would have no legitimate expectation of privacy because her rights to admit or exclude would be subject to her parents' veto. Well, so would a minor child, for that matter. Thus, Mr. Kohberger, as a son, Mr. Kohberger, as a son home for a week-long stay at his parents' home, has standing to challenge the entry and search in this case, regardless of his authority within the home. And then Section 3, Pennsylvania law enforcement violated Mr. Kohberger's Fourth Amendment rights when they entered searching his parents' home without a valid local warrant. I don't know why she didn't throw in the Pennsylvania Supreme Court, and maybe she does, and the Idaho as well. Pennsylvania courts require a warrant for a particular residence to go after a person police are aware has a arrest warrant. Commonwealth v. Romero. The need for a warrant for a fugitive home for a fugitive from another state is codified at 42 PA CSA 9128 and 9129. Without a governor's warrant, an officer can get a judicial warrant to permit entry into the home. Without either type of warrant, an officer lacks authority, and this understanding also comports with Peyton v. New York. So now here's the question, though. So some states don't allow like a violation of authority, like exercising your police authority outside the parameters of that authority doesn't rise to an exclusionary issue. And that might be why she's pushing to have Idaho's exclusionary rule apply, but we'll have to see. The Idaho arrest warrant could not give the police, no, in Pennsylvania, authority to enter the home. I think that kind of goes without saying. State warrants have no extraterritorial effect. The use of an out-of-state warrant is ipso facto a warrantless entry. Thus, law enforcement in Pennsylvania could not rely on the existence of an Idaho arrest warrant to enter the home. And that's why that paragraph is very short, because it's like, duh. Not duh like her. It's like, come on, you guys. And then she does cite that there's an Idaho Court of Appeals decision, State v. Brainig, that seems to be counter to the holding in Bradley. However, never mentions or analyzes Bradley and does not appear to be aware of it. The holding in Brain could not have overruled Bradley, and thus it remains the governing law in this state. Wow. I mean, I guess, duh, except for this judge in State v. Brainig. Federal and Pennsylvania law enforcement violated Mr. Kohberger's Pennsylvania, here we go, and Idaho constitutional rights by not knocking and announcing their presence and presenting Mr. Kohberger with the opportunity to surrender. As noted above, Idaho's law should apply to the entry in this case. However, Pennsylvania, like Idaho, has rejected the good faith exception. Similarly, and insists upon suppression where the knock and announce rule has not been complied with absent exigent circumstances. The Pennsylvania Supreme Court has only found 4 exigent circumstances permitting police to ignore the knock and announce rule. 1, the occupant remains silent after repeated knocking and announcing. 2, the police are virtually certain that the occupants of the premises already know the purpose. 3, the police have reason to believe that an announcement prior would imperil their safety. And 4, the police have reason to believe evidence is about to be destroyed. And then footnote 11 just kind of popped right there. Even though exigencies are enumerated with the conjunctive and, courts have held that any one of the instances justifies noncompliance. Well, yes. So I think this very much has legs to me, even way stronger than the earlier motion.
Really?
Mm-hmm. And they've passed a lot of even federal statutes about knock and announce after all of that. I mean, I was very much paying attention to it while it was in like being tossed around between the House and this. No. Yeah, sure. Some of it was absolutely passed. So there's a lot of strong support for a violation of knock and announce really requiring exclusion, although it was starting to move away from that. Like it was starting to be like, all right, this not going to announce thing doesn't seem like that should be like you're throwing everything out because of it. I mean, I'm sure it's a huge problem in Philadelphia that I would expect that they've got some strong case law on it. But Idaho's understanding of the knock and announce rule is set out in Roush. In Roush, the court did not adopt a test such as that in Pennsylvania, but held a case-by-case analysis must be made. The general circumstances which have been found to constitute exigent circumstances are 1, a reasonable belief that compliance with knock and announce statute would result in destruction of evidence, or 2, a reasonable belief that compliance would place the officer in peril. And they cite two cases there. In this case, there is and can be no showing of these exigencies. Mr. Kohberger has been had been surveilled by the FBI for weeks. At no point during the surveillance was he seen to have any weapons. There was no reason to take him inside the house, as surveillance undoubtedly was aware of his daily runs. The evidence the police sought was simply not the kind of evidence that giving him a chance to exit the residence would have imperiled. In State v. Ramos, Idaho 2005 case, our Court of Appeals held that an officer knocking and announcing and then breaking the door 2 seconds later was done without exigency, where the only evidence offered was that large quantities of drugs were believed to be within the home. So that's like a big loophole. That's like your typical law enforcement loophole. They knock and then they barge right in. They don't even give you a chance to get there. And there is a lot of case law on this issue as well. And that's why, again, breaking the door is, is something that they consider. If what they did was, the more egregious their conduct on the failure to knock and announce, the more likely they will find exclusion to be the appropriate remedy. So
Yeah,
there,
I
the
mean,
court.
our homes are our castles.
Yep.
Like the home is sacred. That's the one place where hopefully they'll always uphold the law in terms of what law enforcement can do about getting into our homes.
Right. So there, the court said, the state urges us to also consider the district court's finding that SWAT officers approaching the front door of the house were exposed and could be easily seen by any occupant of the house looking out the window. We are unpersuaded. The police would have been aware of any of the tactical environment of the front of Ramos's house when requesting a warrant, and the record indicates that they did not seek a no-knock warrant on these grounds. Like, haha, guys, no, you can't try to rewrite this shit. We note also that the visibility of the area in the front of the house through the windows of the Ramos home, as described in the district court's opinion, seems typical of most residential houses. We do not accept that in every case, the exposed nature of a suburban home is in fact giving rise to reasonable suspicion of some exigency, allowing for near immediate police entry into a private dwelling. There is little difference between what, if anything, the officers could claim required the destruction of the Kohberger's home and what the state relied upon in Ramos. Pennsylvania cases show that the failure to knock and announce in this case was egregious. In Chambers, detectives covered both doors of the residence, knocked, and then immediately shoved the defendant back into the house the moment he started to open the door while aiming their weapons at him. The Supreme Court found that the forcible entry was completely unwarranted. In Commonwealth versus Kitchener, a 1986 Pennsylvania case, the court found the exigent circumstances where the defendant had a history of violence and fleeing police, and after they announced themselves, heard running and believed the suspect was either fleeing or going to arm himself. By a history of violence, the defendant had arrests for attempted murder, aggravated assault, and assault with a deadly weapon. He was known to have a handgun in his car and was reputed to be a person who liked guns, machine guns in particular. In comparison, Mr. Kohberger has no criminal history, no reputation for violence, or even being a gun aficionado. It makes no sense that police were willing to announce themselves in Kitchener, but not to him. Taking all the allegations in this case as true, there is still no explanation as to why a small army was required to capture Mr. Kohberger. Given the force the police decided to use here, there was no reason whatsoever to break down the front door, shatter the basement sliding door, and point guns at the inhabitants. Section 5, the affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. Okay, so now this is the part that, well, no, this part goes a little different, actually. The Fourth Amendment states unambiguously that no warrant shall issue but upon probable cause supported by oath of affirmation and particularly describing the place to be searched and the person or things to be seized. U.S. case to United States Supreme Court case, Grove v. Ramirez. Probable cause exists when all the circumstances set forth in the affidavit, there's a fair probability that contraband or evidence of a crime will be found in a particular place. Citing United States Supreme Court, Illinois versus Gates, it's 1983. The right of a man to retreat into his home and there to be free from unreasonable government intrusion stands at the very core of our Fourth Amendment. Kylo, U.S. Supreme Court, 2001. Courts have firmly established that the basic principle of Fourth Amendment law that searches and seizures inside a home without a warrant are presumptively unreasonable. For a search warrant to be valid, the judge issuing the warrant must rely on an affidavit or affidavits sworn to before the judge or by testimony under oath and recorded that establish the grounds for issuing the warrant. Nunez, a 2003 Idaho case. Any discrepancies between the items for which there was probable cause and their description in the search warrant requires suppression. It is clear that the issuing magistrate himself, if he is to fulfill the constitutionally mandated function of interposing an independent intelligence between the law enforcement officer and the citizen, he must actually and in fact draw the inferences from the evidence presented to him. Okay, so this now goes to the same thing they said before, that they have to give them all the information, and it has to be no omissions, no falsehoods, and that omissions are material. And then that they're gonna they issued all that information in the under sealed proffered for the Franks motion. Section 6, the affidavit submitted in support of the application for the issued search warrant included information that must be excised. Where information in a warrant is obtained in violation of the Constitution, Idaho courts excise that information. All information in the affidavit was gathered because of law enforcement's unconstitutional use of the investigative genetic genealogy, and thus nothing else should remain. Now, Bob, this is the part that you've already read, right? So I'm not going to redo this. All right, I'll just do it.
Is that the part?
Mr. Kohberger has argued in a separate motion that genetic genealogy investigation in this matter was done in violation of the Constitution. Additionally, he argues that there would be no investigation into him without the original constitutional violation. It is not that the results of the IGG sped up the investigation. Instead, they focused the investigation on Mr. Kohberger, a person whose only connection to the case was his mode of transportation and the shape of his eyebrows, two identifications of little to no value, as previously argued. As the Idaho Supreme Court has explained, while the initial burden of showing a factual nexus between the illegality and the evidence, the state must show it would have been discovered anyway. And that's the Majas, Idaho 2022 case. The state cannot make this showing. Without IGG, there is no case, no request for his phone records, surveillance of his home, no DNA taken from the garbage out front. Because IGG analysis is the origin of this matter, everything in the affidavit should be excised. B, information about the client's location taken from his phone. They're saying is that there was an invalid warrant. Separately, the information gathered via the warrant of Mr. Kohberger's AT&T account and the pen trap and trace device warrant should be excised for the reasons set out in those motions. So this is kind of the way you have to do it when you've got like okay. Whoops. All right, Bob, I'm sending you this. Like, needs to happen right this second, apparently. Okay. So anytime that you've got like a warrant that's relying on other information that now you're also saying that was discovered illegally, you kind of just have to loop them in to each one like she's doing here. So Section 7, Statements after arrest are either fruit of the poisonous tree from the illegal arrest or should be suppressed as a Miranda violation. Any statements post-arrest of Mr. Kohberger are fruit of the poisonous tree from the unlawful arrest. In addition, the statements made as soon as he was placed in zip ties and held at gunpoint to many police officers without Miranda warning should be suppressed. To protect the Fifth Amendment privilege against compulsory self-incrimination, police must inform individuals of their right to remain silent, the right to counsel, either retained or appointed, before making a custodial interrogation. The requirement for Miranda warning is triggered by custodial interrogation. A person need not be under arrest to be in custody for Miranda. And they cite Parkinson's case that also cites back to Frank's, saying short of an actual arrest, the safeguards prescribed by Miranda become applicable as soon as a suspect's freedom of action is curtailed to a degree associated with formal arrest. The custody test is an objective one. It is not based upon the subjective it's not based on the subjective impressions in the minds of either the defendant or law enforcement officer. The only relevant inquiry is how a reasonable man in the suspect's position would have felt under the circumstances or would have understood the situation. And that goes back to Frank's. Again, custodial interrogation means questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action of any significant way. Interrogations include not only express questioning, but words or actions that the police know are reasonably likely to elicit an incriminating response. Mr. Kohberger was zip-tied after a no-knock warrant was served. He was zip-tied at his hands and surrounded by police at gunpoint. Law enforcement did not Mirandize him immediately. Instead, they waited until after he was transported in a police car, handcuffed with at least 2 officers. One was seated next to him in the back seat. They cite to Frank's again when they for the proposition that a defendant was in custody for the purposes of Miranda when he was questioned while handcuffed and restricted in the area of a patrol call of the patrol car. A reasonable person in Mr. Kohberger's position would have understood himself to be in custody. All right, so this is all we're getting, I think, about the conversations. 2 conversations took place before Mr. Kohberger was Mirandized at the police station. It is clear from the police station video that detectives asked him if he had ever been Mirandized before they said they needed to go through the formality of Mirandizing him. He said no. No video or audio recording of the entry into the home and initial arrest has been produced. Video and audio begin with Mr. Kohberger in the police car. What? Come on, they're going to give us more than that. Oh, here we go. Yep. In determining whether a person has been subjected to custodial interrogations for the purposes of Miranda, the court also considers the conduct of the officer, the nature and manner of the questioning. The conduct of the law enforcement with Mr. Kohberger in his house is referred to as, quote, small talk when he is being recorded during transport. This cannot be verified because no audio or video is produced. The conduct of the officer in the police car during transport cannot be described as an interrogation. However, without a video or audio recording of the custody discussion inside the home, the true nature of the statements made in the car are without context. Now, that's because let's say that they did interrogate him inside and he already made a statement. Then the statements he's making in the car are just him repeating statements he's already made and not been Mirandized, as opposed to just, him offering information without being questioned at all. So all statements made to the police at the police station were post Miranda. Information in the media right after arrest and attributed to law enforcement report that Mr. Kohberger, redacted, Such a statement is not in a police report or in an audio or video recording that can be found in discovering. If it is a statement that the state will seek to attribute to him at trial, it should be suppressed as a non-Mirandized statement. If the conversation with Mr. Kohlberger inside the home was custodial in nature, the context may warrant suppression of the conversation in the police car during transport. Mr. Kohberger requests that this court suppress all evidence obtained by police via warrant that permitted him to search his parents' home. As explained above, law enforcement failed to knock and announce before raiding the home. The warrant lacked probable cause as written, given its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate judge to draw its own conclusion, and because the warrant omitted exculpatory information and information that put into question the reliability of the facts upon which it relies. And finally, because the affidavit relied on evidence gained in violation of the Constitution, all in violation of the Fourth Amendment and Article 1, Section 17. Any statements made by Mr. Kohberger are fruit of the poisoned tree of an illegal arrest. Some statements may be excluded under Miranda.
So I mean, what I was trying to do, I was trying to pull up the return of warrant from the house to see exactly what they had pulled up, like what they grabbed during that search of the house. You know what I mean? All right, this is gonna have like what we're doing on our cell phones is gonna have to wait for a few minutes, Al. Like this should have been dealt with like earlier. Seriously,
Well, we're about to wrap up anyway.
I've got like 6 motions to read still. Like I don't know what the hell you're talking about, man.
6 more.
Yeah,
There's more days.
done, girl. Well, tomorrow I'm doing Diddy. Like we're doing the Diddy shit before his hearing on Friday. So I got to like figure out, like, I want to get through this Kohberger stuff. It's fascinating. There's a lot of it. There's a lot of it. So let's see. So I mean, like, why do you think, like, what is your impression? Why do you think that has more legs than the Google search, where the law is very clear in Idaho?
I don't know that the law is crystal clear because she kept circling back to that Miller case saying that, you know,
I mean, but you have to address law that you're, you know, pretty much convinced that the court's going to try to apply to shut your shit down.
well, like I
Right?
said, it's
Like,
going
you
to
have to
depend
address.
on what actual, if all they looked at to find that was 2 weeks of data of purchase history, well,
Okay,
that,
well, let's assume that they found the purchase of a knife.
yeah, but what I'm saying is, did they search through just 2 weeks of purchase history and that was it? And that's the extent of the search where they found that thing? Or were they all up in his business and they found it? That's the questions that these motions aren't answering. Again, here we don't even know what happened inside the house. What did they or it sounds like maybe they're only looking to suppress statements, not.
No, I mean they pulled some shit from the house. Like,
Well, then why is there not one thing that says, as a result, we need to suppress X, Y, Z? Like, you're supposed to identify it.
all right, wait. Here, Sleuthy sent me the.
All right, I got to be right back. I get it.
All right, so let's see here. So the. All right, so they pulled the. Let me see if there's a way I can get this up on screen. Bear with me. Sleuthy sent me the return on warrant for this. All right, I want to pull it up because it helps to know what they're going to try, what she's trying to suppress for certain. Oh, okay. Okay. All right. See, that's why Sleuthy is the best. She's the best in the business. Like in terms of this kind of shit, Sleuthy's the best. All right, let me see. Just the best. Pull this guy up. All right, so this is the warrant for the house. Let's see. Let me move it to scrolling. All right, so this is the shit they pulled from the house search. The knife or a knife, a book with underlining on page 118, an AT&T bill for Brian, a Glock 22, Gen 5 40 caliber, Smith & Wesson pocket knife, folder containing vehicle paperwork, Acer laptop model, green leafy substance in green container, documents, green leafy substance in plastic bag, white paper with password, power cable, cell phone, 3 Glock 40 caliber magazines, empty, books, black face mask, prescription, black gloves, 1 black hat, 1 black mask, New Balance shoes, dark colored jacket. Does that say, is that dark? I don't know what the fuck that word is. Dark jackets. What a dark colored shirt, dark colored shirt, dark colored shirt, dark colored pant, dark colored pant, clear plastic glove. 1. What does that say? This guy had shit handwriting, man. I think 1 Acer laptop with damage, 1 something laptop with damage. I'm looking at 26 or 27 if y'all can read that. I don't know what that says. Another gun safe Glock item, photograph but not taken, hole in the desk, criminal psychology book, documents. All right. Extra large Columbia Navy fleece. What? So this was interesting. The IDs. So this is obviously the car, right? So this is the ID cards inside of glove, inside of box. I remember when this came out, that was the thing. That one thing was blowing. I'm like, what is that? Numerous for various criminology books, a license, a card, dark colored black glove, Seagrave Barracuda, 1 terabyte Samsung, solid state drive, black box Samsung, 2 pairs of black gloves, 1 black knit hat. Dark green short sleeve shirt, black long sleeve shirt, black sweatshirt, gray jacket, 2 pairs of black pants. I mean, so they dug up everything, from every room in the house. Motherboard.
All this stuff came from the parents' house?
Yeah.
What did he do?
Washington
Like,
State
bring his
University
whole
paperwork.
department over there?
I mean, it's like they went through the whole house. Clearly, like, this shit's not his. I mean, we saw his car when they were driving, when they pulled him over twice in Indiana. He didn't have much in there, it didn't look like.
Right.
Note from Brian from Montana, Craftsman shop vac. Like, why are they taking a shop vac from his parents' house?
Right, but I thought they took it from his place to check the
No,
vacuum to see if he got anything, but what
no,
kind of
they
evidence
did.
would
They
say it's
did
his
take
parents?
the vacuum container from his house
Hmm.
as well. Court documents, medical documents. Note to dad from Brian.
Sorry, Dad. I
Maroon
might be
colored
going away
spiral
for a long
notebook.
time. Please still love me.
HP all-in-one computer, Lenovo IdeaPad laptop,
Oh, they read it real big. Got those dark colored boots and brown boots.
2 pair of dark colored boots, 1 pair of, it seems like a different dude started writing this shit. This
Yeah.
guy's writing's worse than mine. That's saying something. Taylor cutlery knife with
I'll be
leather
interested to
teeth,
know what the defense is on this thing. I mean, because I remember she wrote some kind of
4
motion
swabs.
that was like, this he's not the one.
So they took 63 items that she's trying to suppress there. You know, and I mean, the reality is that when we're trying to suppress something, we're trying to suppress it because it's inculpatory.
Or can be interpreted in that way.
Right. Yeah. But I mean, like, they literally went through and went everybody's drawers in the house and took every pair of black pants they could find and every dark
Found
colored
a pair of
shirt.
black pants.
All right. So, all right, what are we're on two
Is
and a
it
half
is it
hours.
possible that the motion to suppress the statements has some, no, it's just gonna have that law, I guess.
This is the search of his person.
What'd they find?
I don't know. Let's go through it. It's short.
Okay.
All right. So this is the search of Kohberger's person at the time of arrest. Okay. This is a result of the search of Mr. Kohberger's person in the Latah County Jail. So issues the affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. Affidavit submitted in support of the application for the issued search warrant included information that must be excised. All information in the so again, she's really hearkening back on the IGG stuff. And then information gathered about Mr. Kohberger via previous invalid warrants must also be excised. So, due to the haphazard way in which law enforcement has kept and disclosed records in this matter, the following is the facts as the best the defense can tell. On December 28th, Trooper Larry of Pennsylvania State Police became aware of the objective of arresting Mr. Kohberger.
Kohberger via my
Huh?
Sorry, it's just like we've read this. This will be the 4th time.
Yeah. Well, no, it's a little different. The other thing was when they were like circling the house and when they were getting the warrants and like they're, because they do what they do. It's like it was they were doing all the searches simultaneously.
Right.
you
No,
know.
I mean, she's gotta regurgitate the facts.
But I mean, these are different facts.
They are, I see it. I hear what
Yeah.
you're
So
saying.
on December 29th, the magistrate in Pennsylvania issued the search warrant for the house. On the 29th at 2:22 p.m., the magistrate in this matter signed an arrest warrant in Latah. The affidavit for the warrant was signed by Moscow. The basic facts that they used were as such. At 2:43 on December 29th, the criminal complaint and probable cause order were filed in this matter. At 10 p.m., Pennsylvania SWAT began prep to arrest Mr. Kohberger. Despite days of constant surveillance, Pennsylvania law enforcement did their own surveillance starting at 11:15 p.m. And despite the fact that days of constant FBI surveillance, showed that Kohberger was unarmed, tended to go for runs around his neighborhood, parents' neighborhood, police decided attacking Mr. Kohberger within his parents' home was the best option. So on December 30th at 1:14 a.m., SWAT raided Kohberger's parents' home, and he was arrested. At 4 a.m., Pennsylvania State Police filed a criminal complaint against Kohberger. On January 4th, Kohberger was flown to Latah County Jail. On the 5th, Sergeant Blaker requested a search warrant for Kohberger's person, relying upon the same facts articulated for the warrants used in Pennsylvania. Later that day, Mr. Kohberger's person was searched, pictures of his body. See, that's what it is. It's the DNA swab. I'm like, what does he have with him? Like jammed up
Right
his,
in the jail. That's what I was wondering. He got all the
yeah,
way.
it's his
Got
DNA shit for sure. His DNA swab was taken by members of the Idaho and federal law enforcement at the jail. The argument affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. All right. So this is, she basically goes through the same argument here.
Yeah.
So
I was
she's
wondering if I would have done it differently and put all of the warrants, like put all of the facts and then say, as a result, we're challenging all of these warrants. But I think this was the best way to do it because, then she focuses on the law specific to, that item and then can just keep kind of saying, and then we've got all these other warrants.
yeah. So I
Give us
mean,
the
it's
conclusion.
that's like we're not. It's the exact same argument.
No, just the conclusion I'm saying.
Yeah, we'll read the conclusion. So, Mr. Kohberger requests this court suppress all evidence obtained by police via the warrant that permitted them to search his person. As explained above, this warrant lacked probable cause as written, given its heavy reliance on conclusion reached by law enforcement without the details necessary for a magistrate to draw its own conclusions, and because the warrant omitted exculpatory information and information that put into question the reliability of the facts upon which it relies. And finally, because the affidavit relied on evidence gained in violation of the Constitution, all in violation of the Fourth Amendment and Article 1, Section 17. So I have a feeling that that was the person.
I mean, that it's all, like you said, it kind of all depends on
That was his person too.
which
So,
domino falls.
well, I mean, the question becomes if the IGG stuff does not fall, which really was the smoking gun in that probable cause affidavit. Like that was the thing that, in terms of getting it in front of a judge and sliding it up on his or her bench and saying, all right, this is what we got. And the judge, like the last thing that they're mentioning is that, oh, by the way, got all that stuff with the video and the car. And
Well, where's the motion about the taking the DNA, or did we read that? Was that long ago?
that was it. They got his DNA in the jail.
No, I mean the search
Oh,
of the garbage. That was, did we cover that motion a long time ago?
let me see. So that's because you just did the house, right?
Yeah, but I think there's 2 for the house. The one that would deal with the taking of the garbage, the searching of the garbage, and the one that dealt with the arrest warrant.
All right, so this is the one that you just read. That's forensic lab. So that's the cell phone. AT&T's first warrant. The Google warrant. Memoranda.
I mean, at the end of the day, while you're looking through them to see what else you got there, at the end of the day, all of these warrants are over broad, not particular enough. They're encompassing way more information than they need to. And then the question's just going to be, did, you know, any of these rise to the level of egregious enough to either a Fourth Amendment violation or a state constitution violation that warrants exclusion under the
Or are they going
exclusionary
to
rule?
hang their hat on good faith?
You
I
just said
mean,
that none of the states involved uh, accept good faith exception.
yeah, let me see. Let me look at the emails again.
All right, you
So,
look at those. I'm going to start going through. some of these while you do that. Thanks, cool lady, for your 5 Defense Diary memberships. Appreciate it. Forrest Nelson, member for 3 months. Yay. Meg, wow, 20 gift. I hate when I do that because then it's like, did I just disparage cool lady and her amazing 5? So I don't mean to be, but thank you very much for 20 Defense Diary memberships gifted. And Jason McClelland, thank you for your generosity. So what DP methods are death penalty methods are cruel and unusual punishments in the US. Then you have to propose another method. So I think that what she was saying, the firing squad they don't use anymore.
They do there. They just
And is
re-up.
that the one that she's saying that they don't know the pain, like that? Because I
I
thought
think
the argument was there was
firing
some
squad's the
combination
best.
of medication that they didn't know.
Well, no, they can't use the firing squad if they can only use it if they can't get the magical elixir, which apparently is very difficult to get
All right.
because it's not easy.
Crypto tax lawyer, hello, and thank you for your generosity. Well, I ain't past the bar, but I know a little bit enough that you won't illegally search my shit. Hit me. Is that it? Oh, name what tune that was. I didn't do it right. Got anything, babe?
For what?
She's quoting song lyrics. Well,
Oh
I ain't
no,
past the bar, but I know a little bit enough that you won't illegally search my shit. Hit me. Name that tune. Well, what?
I don't know. Hold on, I'm trying to look through these things, dude. You
All
do
right.
deal with this stuff.
She'll tell us.
We get the pen trap and trace, which will be an interesting one too.
Life-changing 10 months. Thanks, Pokemon. Glad to see you. Thanks again, crypto tax lawyer. This financial privacy and autonomy is why everyone needs Bitcoin. Yeah, true. Except then you have the fear that Bob just said that I've always been worried about like that. Like, what's my money? Where is it? And how do I know some hacker doesn't get it or just doesn't disappear? Blockchain will revolutionize medical records and evidence in criminal and civil trials. Writing a piece on it, we'll share. All right, we'll keep an eye out for that. Thanks. Kenny Powers, thank you for your generosity. Kohberger is a saint who should be praised by all. I mean, I don't know if that's sarcasm. I mean, like I said, I kind of have no opinion. I really thought he was guilty, like at first, based on everything. Or, obviously he's innocent until proven guilty. But I thought, like, this sounds. Actually, I think I was. Now that I rethink it, I was like, what? His eyebrows. Uh, you know, but there was a lot of circumstantial stuff there, at least it seemed like it. But, so, I don't
I
know.
mean, the bottom line is you always got to wait to trial.
Right,
You know what I mean,
right.
it's like I don't know how many times we have to say it. It's like I don't guess on shit like before it goes to trial. Like that's just I'll say a PCA leans heavy innocent or leans heavy guilty or leans not heavy, just leans one way or the other. But in terms of until the shit's vetted, in terms of you got to go through these pretrial motions to see what stands, and like
Mhm. So
I'm going to go ahead and assume that nearly all of these are going to be denied. I mean, it's really tough. You've got to
what do
have.
you mean he's made a statement without being Mirandized? We don't know that
We don't know
yet.
what he said.
Oh.
I mean, is it like? I mean, like what? I don't see the like. We're gonna have to go back for
I
that
think it
search.
was covered some other time. But Miss Potts asked, Defense Diaries podcast, would you consider it Frank's material for a filing if an officer on one of your cases withheld from the judge other DNA was found at the scene in close proximity to the victims? I mean, it would all depend. I mean, like on like a number of other things. But if there was a bunch of other stuff that pointed to another victim and this other DNA has been identified and it's not connected to the people and it's not connected to the defendant, possibly, um, you know, but it's, we file a lot of stuff that ultimately gets denied anyway.
Yeah.
But thanks for the question.
I mean, you
And,
have to make the record one way or another, you know. I mean,
and Bear Jew says, free Brian Kohberger, all eyes on Idaho.
yeah, I think Bear
Brian's
Jew is sarcasm. Like Bear Jew is very much of the doesn't care about all the shit that went weird with Allen. He's like Bear Jew is just sold on that case. Bear Jew, we're
Oh,
just
well, I
gonna
would
have
hope
to
that
agree
Bear
with
Jew would
you.
take each case as it comes individually and
I
never
mean,
always be on
a
the
lot of
side.
these folks don't do that. They just think that everything's the same thing and like every case is completely different from one another. Like totally. Like, there's no bleeding one case into another. It's
No, but what I'm
bizarre.
saying, like, take a case, don't always assume they've got a guilty person, like, take and look at each case, give an
Yeah, I
honest.
mean, most of the times they get the right person. I mean, most of the times, I mean, that's an important point to make because then it validates like if we're digging in so deeply on Richard Allen, something stinks about it.
Yeah,
Like
that
I don't
well,
know what else to
there
tell people.
isn't a lawyer in the world who didn't say something. I mean, like, when every talking head, every legal consultant, every criminal justice consultant across every aisle known to man says there are too many questions and I just don't see it and it doesn't make sense.
No, there's one dude. Who is he? There's one lawyer that I saw him on. Nancy Grace had him on. Phil.
I think
No,
Nancy Grace has got someone who will say anything.
it was what's his name? I like him. He's a really nice guy, but like he's been kind of the mindset that they had a really strong case against Allen. I'm like, all right. I mean, look, everybody is entitled to their opinion.
Right.
I'm just entitled to mine as well. And this thing's not over. Like everybody thinks that they're going to be able to relax on this thing. It's what I was telling everybody from the get.
All right,
But the
my
whole
computer
problem.
is about to die, so I think we should
Oh,
wrap
you
this
should
up
plug it
instead
in.
of me
All right,
getting a
did you go
charger.
through it? All right, you're all like we'll come back and do the rest of these. I think a lot of them are kind of the same argument in a lot of them. I think I'd like to do the
Trap and trace.
trap and trace and the iCloud ones. I
Yeah.
think that those two are
Yeah, the
worth.
iCloud that's a huge one because that carries a lot and there wasn't a search warrant, apparently. She says there was just a warrant to seize the information, just to get the information,
Yeah,
which
yeah, and like I think that that's going to be worth our while. And tomorrow we're digging into some Diddy in anticipation of his court date on Friday. Dude's still trying to get bonded out. I
I
know.
just have
How
not
many
paid
times is
enough
this guy
attention to
going to
that.
try to get bonded out? Nobody's letting his ass out. Nobody.
He's a flight risk for sure,
He
I
is.
guess.
He is like if you look up flight risk in the dictionary, it's a picture of Diddy right there. Like that dude is like the epitome of a flight risk. Like I don't give a shit if he gives up his passport, if he's got like they got
Well, he
the
wants
shit
to,
on his
like,
ankle.
I don't know.
What?
I don't know enough about it. It sounds like he's needs to stay in jail.
Uh yes. I mean, I've asked her, Polly. Like I'm absolutely convinced of that. Like, I mean, more importantly, she's convinced of it, but it's like it's one of those things like can you ever really know somebody? I mean, it's like it's hard to know. But yeah, I mean, in terms of Kathy, she absolutely is 100%. Um, DB, Quit asking ridiculous. DB? I'm not the only person who refers to podcasts as pods. And if I am, I'm going to trademark it because it's awesome.
Awesome.
All right, you guys are amazing. Thank you for
Thanks,
all of
guys.
your generosity to our mods. We love you. We adore you.
Yes.
Mandy and Dizzy, thank you for all your hard work today, getting me all the deets. Sleuthy, thank you for getting me anything I need when we're kind of like on the run in terms of filings, warrants and cases, all the amazing things that you're able to pull up for me. All right, y'all, you guys are the best. We will see you tomorrow. Thanks for the hang. And remember, without y'all, I'm just an old man and a super hot chick. Talk about a bunch of cases. Later.
Hot